Superior Court is now in session.
Your Honor, for the record, this is a continuation of the trial in Commonwealth versus Cara Rintala, Hampshire County Indictment number 1180CR128.
Morning.
Good morning.
Morning, Your Honor.
All right, so the Commonwealth has rested. The defendant has filed a motion for a required finding. I did have a chance to review the written motion, but I'm happy to hear from both counsel.
Sure, I'll address it briefly, Your Honor. So, our position ever since the beginning of this case, since our motion to dismiss, has essentially been unchanged. In our view of the Commonwealth's case, now that we've heard it, is that it reflects exactly what we had expected, which is, at its core, a case built impermissibly on speculation. The core of the Commonwealth's case depends on the evidence of the testimony of forensic pathologists about time of death. And unless they can place Cara Rintala in her house at 3 p.m., before 3, unless they can establish time of death occurred before 3 p.m., they cannot establish that Cara Rintala killed her wife. And first of all, Dr. Richmond gives testimony that the time of death was 6 to 8 hours before first responders noted rigor mortis. And putting aside any questions about the qualifications of police officers to establish rigor mortis, and side note, I hope it's clear to the court that this distinction between police officers and paramedics is something of shell game. Michael Pandora, as we expected, admitted he didn't even touch the body. Gene Oss, although he's built up as the most experienced of the death scene investigators, such as they are, merely touched her arm and manipulated her shoulder merely to decide whether or not she was dead, and therefore to give life-saving procedures. These paramedics can establish whether it's not their job or their training to establish how long somebody has been dead. But that's all really a side note. The police officers, who have much less training, much less experience, and indeed had never investigated a homicide in their lives, tipped her body over. 3 people moving simultaneously apparently established a lot of stiffness in the body. Accepting that that is evidence of well-developed rigor, the testimony is that generally occurs in 6 to 8 hours. Dr. Richmond agreed that vigorous struggle immediately before death accelerates the period. She has now backed off of prior trial testimony, abandoned prior trial testimony, that cool skin temperature is a meaningful material indicator of time of death. So what she's left with is rigor, which everyone agrees is an unreliable single factor for establishing time of death, plus undisputed evidence of violent physical struggle immediately before death. She agreed that the claw marks on Ann Rintala's neck, or the abrasions on Ann Rintala's neck, were consistent with claw marks, consistent with the literature that when someone's being manually strangled, it's typical to see those sort of claw marks as a defensive mark to get the strangler's body off, arms off of you. So from our point of view, and then ultimately, when pressed on the question, all that Dr. Richmond could do, and this is the crucial point for her, all she could do was speculate that perhaps Mr. Rintala had, in falling down the stairs, had fallen down the stairs, but in falling down the stairs had become dazed, and therefore the struggle had been shortened. But that is, we have lots of evidence that about the struggle. The struggle, the evidence indicates, started on the doorstep, went through the entryway, went down the stairs, was, given the blood we see, was around the basement. And so we have lots of evidence of an extensive struggle. And so we have clear evidence of a violent struggle and no evidence to support this speculative theory that perhaps she was dazed and that shortened the violent struggle, and further speculation that with a shortened struggle there would be minimal impact on the time of death calculation. This is all rampant speculation in a murder case. Dr. Andrew was essentially testifying to the exact same thing. He says early morning, mid-morning to early afternoon, apparently comfortable with a range roughly 10 to 1 p.m. And then through cross-examination, reduces that range to essentially no range at all, 12:21 to 1 p.m., but definitely no later than 1 p.m. But again, the exact same pattern. He is relying entirely on well-developed writer, a single factor, which the literature and every pathologist tells us is a very unreliable factor for establishing time of death if it's the single factor we're using. He admits, again, just like Dr. Richmond, there is evidence of a violent struggle, and he admits that a body habitus being large, a BMI of 33 or more, would accelerate the onset of rigor mortis. So there are two factors he admits accelerate the onset of rigor mortis. What does he say? He does not rely, like Dr. Richmond, on the speculative theory that she was unconscious or dazed right before the strangling, shortening the period of struggle. Rather, he agrees that there was an elaborate period of struggle, but he says that was likely offset by the ambient temperature in the room, which he put at 71 degrees, which he described as cold, and the fact that she was lying on a cold concrete floor. We don't know how cold, but in this room with 71 degree ambient temperature, and that she had, in his words, little clothing. And he said that it was essentially a wash. In other words, that the accelerating factors of a violent struggle and a large body habitus, BMI over 33, is offset by the factor of a cold ambient temperature, 71 degrees, and the fact that she's lying on a cold floor. And respectfully, there's no data to support that, and indeed it seems to be contradicted by the evidence. The evidence is that when you have a violent struggle that uses up the fuel in the body, rigor mortis is a chemical process where the fuel, the ADP, the energy in the muscles is being used up. And when it's used up, the proteins manifest, they stop moving, and they manifest in stiffness in the muscles. The body habitus being, the ambient temperature being cold doesn't affect that chemical process. It uses the burning of the fuel. If there is no burning of the fuel, arguably it could slow down the rigor mortis, the chemical process. But here there is clearly a burning of the fuel by a vigorous struggle immediately before death. So in other words, that is the most important factor here. It accelerates the rigor mortis. And the bottom line, the very simple bottom line after that little digression for science, is that both of the Commonwealth's experts rely on speculation that is unsupported by the evidence to arrive at a magical time before 3 p.m. And it's simply speculation. And without that piece of evidence, the Commonwealth's case falls apart. And we submit that no reasonable jury could find Mr. Rintala guilty beyond a reasonable doubt without relying on speculation. That's the core.
Okay, thank you. Commonwealth?
Thank you, Your Honor. We would suggest this motion should be denied. The defense continues to, recap and characterize the evidence in this case in a light most favorable to the defense, rather than the standard that this court has to apply They continuously claimed that certain testimony was, quote, undermined or unreliable, but reliability is within the province of the jury. Our evidence in this case has come in substantially similarly to how it did in the third trial, which the SJC found was sufficient to sustain a conviction, and also, as counsel noted, a motion to dismiss the case was previously denied on representations that our evidence would come in essentially the way that it did. We believe there's sufficient evidence for the jury to find that the defendant was home alone with the victim at the time of the death, that she applied 3 to 4 minutes of sustained pressure to her neck, and that this would support a verdict for not only extreme atrocity or cruelty, but also deliberate premeditation. So we would ask that you deny this motion and allow the case to go to the jury. Thank you.
All right. So applying the Lattimore standard, as I must at this stage, I am denying this motion.
No objection.
Because there are 2 other issues that I'd like to address before the jury comes in. One is we received about 1,000 pages of information from the Commonwealth last night, about 280 as it relates, they claim, to Dr. Littman, and about 700 and something as it relates to Dr. Arden. The information with respect to Dr. Arden, Judge, is information that the Commonwealth attempted to introduce at the second trial. It's information about a lawsuit, apparently, that Dr. Arden was involved in that had been resolved. Judge Rupp heard the evidence and excluded it, told the Commonwealth they can't use that evidence. In the third trial, they didn't try to use it because it was Judge Rupp again. And here we are with a new judge, and now I guess they're making another attempt to introduce this evidence in cross-examination of Dr. Arden. The evidence, Judge, is some suggestion of a completely separate, unrelated lawsuit, which actually settled in Dr. Arden's favor. But the Commonwealth wants to get to be able to cross-examine Dr. Arden on some of the claims within that lawsuit, which I think are completely irrelevant and not pertinent to anything that's relevant here. So it's not a situation, Judge, where any other, especially Judge Rupp, found was credible or that it was in any way reliable. So I'm asking the court. I do have the cites to Judge Rupp's decision. It was January 23rd, 2014, when this issue comes in. And so what Judge Rupp essentially says, that it was impeachment on a non-medical issue, and that, I figure out where Judge Rupp, and that for the purposes of the non-medical issue that the Commonwealth was seeking to get into, Judge Rupp excluded it. So I'm asking for this court to make the same exclusion, and I think that the information regarding that prior issue that was non-medical was something in the area of like 600 pages of information that I was reviewing for the first time last night. It appears from the record that Commonwealth turned this over to Attorney Hoos sometime during the second trial. According to the record, it got turned over similar to what they did here, 10 o'clock at night, the night before Dr. Arden was to testify. We don't have it in our file. We actually called Attorney Hoos and Attorney Ryan last night at 10:30. Attorney Ryan did come to the office to try to locate it. He was unable to locate it in terms of what was turned over last time, but he did remember that it was 10 o'clock at night the night before the experts testified. So I'd ask the court under these circumstances to exclude any information regarding impeachment with non-medical, with this non-medical case that actually settled in Dr. Arden's favor.
May I respond, Your Honor?
May.
So just to clarify, yesterday afternoon at sidebar was the first time in this case that Attorney Sulpicio has confirmed that the defense intends to call Dr. Arden. I had been inquiring on this topic repeatedly for quite some time, and it was only yesterday that I learned that they intended to call back Dr. Arden. So upon learning that, I was also working quite late last night to brush up my outline for his cross-examination today, and I thought, out of an abundance of both caution and generous discovery, I forwarded to Attorney Sulpicio, it is true, approximately 700 pages of prior transcripts, and other materials that I've accumulated over the years in confronting Dr. Arden. This will be the third time he's testified in this case, so there was quite a bit. Now, rather than approach Dr. Arden this afternoon with transcripts of prior testimony that Attorney Scapiccio may not have, rather than slow things down this afternoon and have multiple sidebars, I provided Attorney Scapiccio, basically, I opened up my playbook and said, here's everything I might use against Dr. Arden. I don't think that's anywhere required within Rule 14, but I did it in the spirit of fair play. Now, within those materials, there is some reference to the fact that Dr. Arden, he's testified in previous trials that he chose to leave or he retired from the medical examiner's office in Washington, D.C., when in fact his resignation was spurred by a scathing report that was done the same year that he resigned, showing that there was gross mismanagement within the office. So to the extent he portrays himself as just having chosen to leave the office, and I'm sure he's going to tell his experience as the chief medical examiner in Washington, D.C., so he's using that to puff himself up. Well, the fact is he resigned under a cloud, and I think that goes to his credibility and his competency. As far as some lawsuit goes, I'm not getting into any lawsuit. I believe that may pertain to allegations of sexual harassment by Dr. Arden against some employees at the office. Attorney Scapiccio may have anticipated or speculated that's where I was going, but I'm not going anywhere near that. It would strictly be in his role as the chief medical examiner in Washington, D.C. It goes to his credentials, and it goes to his reliability. I believe he's going to be testifying about his experience, and I think it's within the scope of cross-examination. I don't intend to turn this into a trial within a trial. We're not going to wade into the weeds on this, but to the extent he says that he simply walked away from the office, well, there's more of the story, and I plan on touching on that.
And Judge, the concern I have is again, this pattern of sending stuff late last night, which Attorney Gagny wants a pat in the back for. We have been talking about Dr. Arden's potential testimony for months. And he's talked to me a million times saying, take him off your list, take him off the list. I know you're not calling him. And I said, I can't take him off the list. He's on the list. All 4 medical examiners were on the list. All potential witnesses in this case. And they've had this information for a long period of time. The problem I have, and I've told the court from the beginning, is that my experts are of the Jewish faith. They celebrated the Jewish holiday just over this past weekend. That's the reason that they weren't available until this morning. So that Dr. Arden has had 0 time. He was celebrating last night. Apparently there's some ceremony of breaking the fast after the holiday is complete. That happened until well into after 11 o'clock last night. He got on a plane first thing this morning. We expected to land here at noontime today. He's had 0 time to review these 700 pages of information that the Commonwealth sent to us last night. It's going to delay the trial significantly because he needs the opportunity. It's not fair for him to get on the stand and have this information that the Commonwealth just revealed to us thrown at him at the last minute without the opportunity to respond. And so with respect to that, Judge, I'm asking the court to exclude the information that was just turned over last night and to allow Dr. Arden to testify. He's going to be here at noontime today. And just so we're clear, what the Commonwealth said at the very beginning of the trial is, if you have any transcripts about my witnesses, please send them to me. And we agreed, absolutely, we're going to send them to you. And we actually did get transcripts, but we got them 2 days before their witnesses testified, and we made the decision that that was unfair of us to sort of give them that at the last minute. So we didn't even produce it, we didn't use it, because we didn't think it was fair. For the Commonwealth now to say, 8 o'clock, 9 o'clock last night, here, get these 700 pages from one of your witnesses and 300 pages from another one of your witnesses, when they know that this case has been extended beyond what any of us wanted, and nobody wants to delay this trial, it puts both of the experts that we intend on calling in a position where they're going to look unprepared. And they're only going to look unprepared because the Commonwealth didn't give us the information that we would have given them if the situation was reversed. The idea that Mr. Gagny is now saying he wasn't required to turn it over. We had an agreement that we were going to turn over transcripts. Some of the stuff that got turned over last night, the 2 transcripts from Dr. Littman. I don't remember how many transcripts from Dr. Arden, but it's unfair, Judge. It's an unfair surprise. It's trial by ambush. It's not fair. And at this point, Judge, I'm asking you to exclude the information and allow this trial to proceed.
Very briefly, Your Honor.
Okay, I have some questions.
As far as the materials with Dr. Arden, these were turned over to prior trial counsel in 2016. And I assume that the defense has had access not only to Attorney Hoos, but to his file. So this is a reproduction of materials that were not required to be turned over under Rule 14. Thank you.
Okay, so the portion that Judge Roop excluded, is that the portion, Mr. Gagné, that you just discussed?
Your Honor, I'm trying to find the exact language that Attorney Roop used, Judge Roop used. My recollection is that she ruled any mention of the sexual harassment allegations out of bounds, but I believe that his management of the office was fair game. But again, without having reviewed her ruling, that's my best memory.
Okay. And have you provided anything to the defense that was not previously provided to Attorney Hoos and Ryan?
The only materials that I provided for the first time yesterday pertains to Dr. Littman, and that was 2 transcripts of her previous testimony, other cases that I anticipated using today. And again, it's been somewhat of each side, I think, has been strategically going about this case and not committing to certain witnesses until the landscape of the evidence developed. As Your Honor may recall, I filed an emergency motion for reciprocal discovery back in August, and there were 3 forensic pathologists listed on their disclosure. There was a DNA expert, and I was asking repeatedly which ones are you calling, which ones are you not, and the answer was always the same. We'll have to see how the trial goes. And at one point, counsel even represented in open court that it would depend upon the gender composition of the jury. So when I got confirmation yesterday, for the first time, that Dr. Littman would be testifying today, I produced what I had. It's yesterday, for the first time, I was told that Dr. Lindsay Carroll Thomas would not be testifying. So all of the work and preparation I put into preparing her cross-examination was out the window. So this was a late-breaking development yesterday.
Okay.
And as I said, the materials on Dr. Littman, I think, is about 200 some odd pages.
180.
Probably an hour and a half read.
And again, that's the problem I have with that. When we tried to send it to Dr. Whitman last night at around 10 o'clock, the text that we got back to her is that she was hosting a break fast, which I understand to be a Jewish tradition. After the period of a holiday is over, there's a celebration. She was actually hosting that in her house last night, and then came here the first thing this morning. I did print out what the Commonwealth had sent last night. She was sitting outside at 8:45 this morning. I handed it to her. I just think it's inherently unfair, Judge. She was on the list. She was always a consideration. Commonwealth knew that we could call her. And to do this at the last minute, all it does is delay the trial. That's all it does. It delays the trial, because if she's not ready to be cross-examined, then we have to ask for a continuance, Judge. And that's not fair. It's not fair to the jury. It's not fair to my client. And it's not fair to anybody. When they had the information, they could have turned it over to us. And so they filed their motion for reciprocal discovery saying, give me all the transcripts that you have, but you're going to hold back on the transcripts you have till the night before, which is something you did the last trial when this case was tried. It's just unfair, Judge. It's dirty pool, and it's unfair.
Okay. Well, I'm not going to delay the trial, but I'm not going to exclude these 2 transcripts from the cross-examination of this expert. As to the other information, I understand that was provided years ago through no fault of your own.
Not as to Dr. Littman, Judge. The stuff on Dr. Littman was just provided.
I understand that,
Okay.
so I've separated that out.
Okay.
And I would have preferred if that had been provided earlier, but there are a lot of things that have happened in this trial that were last minute, either by accident or by design, and I've seen that on both sides of this case. So I I don't think that it's too much to ask an expert witness to review transcripts of their own testimony in preparation for cross-examination. There have been multiple times that witnesses have been reminded of prior testimony, typically in this case, and so the jury is used to that. But I'm not going to preclude the Commonwealth from using those transcripts in cross-examination, and I'm not inclined to continue this case so that the expert has more time to review them. As to the other materials, I'm not really blaming either side. I understand your position, but it's also true that this material had been provided along with other discovery, and perhaps it was provided at the last minute before the last trial or before the second trial, I think is what I heard. But the defendant has been in possession of that information through her other attorneys for quite some time. So what I would ask is that the Commonwealth simply narrow down what they believe is actually at issue, just to kind of move this along. It sounds as though there may have been information provided that they don't intend to use that was excluded, and perhaps you can both look at the prior transcript. I'll make my own decision, but I think it would be helpful for me to know what Judge Roop actually excluded and what she didn't. So that's kind of where I stand on this.
And with respect to Dr. Littman, Judge, just so the court is clear, there were 2 transcripts that were sent last night, as well as I think 4 or 5 articles that I guess they intend on asking Dr. Littman about. The articles had not been disclosed before. When we disclosed Dr. Littman as an expert, we gave the Commonwealth in the disclosure the article that she relied on. We got an additional 4 or 5 articles, none of which Dr. Littman had reviewed before today. We got those somewhere around 8 or 9 o'clock at night, and again, Dr. Littman didn't see them until first thing this morning. I don't know that she's going to have adequate time to read them and process them and evaluate them for her testimony. My plan was to put one short civilian witness on and then call Dr. Littman. I just think it's inherently unfair for the Commonwealth to put articles in front of her that she's never read, that they've never disclosed.
Well, so let me stop you there. If she's never read them before, if she's not familiar with them, she won't be able to lay the foundation for their introduction, so they won't come in anyway. It's only if she accepts that they are reliable and authoritative that the Commonwealth can ask her about them and introduce them as a learned treatise. So my assumption is that she is probably already familiar with these articles. And again, if not, there may be some issue with her being cross-examined on them.
But here's the point, Judge, that the jury will draw from the Commonwealth's late disclosure of this information. If Dr. Littman says she hasn't reviewed them and they're articles within the field relative to time of death, it's going to look like she's not qualified, she's not prepared. If she reviews them quickly and doesn't have the time to process them and says something that might be inconsistent with her opinion because she hasn't had time to process them, she again looks like she's unprepared and will be less credible in front of the jury. That's my concern, Judge. And these are expert witnesses. There's no reason for the Commonwealth to have sent this stuff last night. There's absolutely no reason. If they had sent it even a week ago, we would have been prepared and we would not be asking for any type of continuation of time for Dr. Littman to process this information. We gave them exactly what Littman said, Dr. Littman said she relied on. And again, we agreed under reciprocal discovery to give them transcripts and other things that the witnesses had relied on. And this court made an order ordering us to turn that over to the Commonwealth, which we did. And the Commonwealth now stands here turning this stuff over at the 11th hour to get an advantage in front of this jury, Judge, and I think it's wrong.
Okay, well, we can take this up at a later point after you've had a chance to speak to your expert to see what she views as her ability to respond to questions about the transcripts, about the articles. It may be that they refresh her memory pretty quickly, that she's familiar with the articles, and that your concerns are moot. But it may be as you fear, in which case we can discuss perhaps creating some space in the schedule for her to for her to have more time to review those materials. So
Just no objection, Judge. And then there was a motion the Commonwealth filed this morning regarding witnesses who may be here today. My understanding is Trooper Megarian was subpoenaed to be here at 9 o'clock this morning, but he chose to leave the state. And my understanding is he's going to be back at some point today. He's told this to the Commonwealth, not me, although the subpoena was for me. And I'm not sure when he's going to be back, but I'm hoping that he's available when we need him in this case, because he was served in hand, and he understood he was served in hand, Judge, and he's a trooper, and he still left the state, as if the court doesn't matter. But what they're asking in this motion that they just filed this morning, Your Honor, is to preclude me from bringing out any information that we, in fact, subpoenaed Trooper Megarian, and we subpoenaed Mark Olasak. I think that's fair information based on a Bowdoin defense in this case, that we subpoenaed them. The Commonwealth is saying that we should be precluded from asking any questions that lead to an inference that the Commonwealth should have called these people. And my suggestion is, they've known it's a Bowdoin defense. We've asked them, we've told them what the issues were in the case. They understood the downside of not calling Megarian because they didn't call him in the third trial. And so for them to now say, okay, if you call Megarian, we don't want you to get in front of the jury the fact that you subpoenaed him and we didn't. First of all, it's going to be in our case in chief, so certainly the jury's going to know anyhow who calls him. But as a result of why did he show up, because he was subpoenaed by the defense, I think that that's fair game, Judge, and I don't know how the Commonwealth is taking the position with the Bowdoin defense that should be excluded.
Our Bowdoin goes to the adequacy of the police investigation. It has nothing to do with trial strategy and who it calls what witnesses during the course of the trial in the case. This is really in response to what I would suggest was an improper argumentative statement at the end of counsel's opening statement, that the Commonwealth had some burden to call certain witnesses, and if not, we were hiding the truth from this jury. So that's a missing witness issue. We have not litigated that. If they're looking for that, counsel is not permitted to get into those issues without court permission to be able to make those arguments. Who calls what witnesses? Of course the jury's going to know the defendant is calling this person as a witness. But to suggest based on questioning, the Commonwealth could have called you, the Commonwealth knows where you are, they could have subpoenaed you, they chose not to, you're only here because you had a defense summons, is not relevant to any of the issues to be decided by the jury. It has nothing to do with the Bowdoin defense. The Bowdoin defense is about the investigation, not about the trial and the determination of who calls what witnesses. So for those reasons, Your Honor, I'm asking to exclude any type of questioning that goes along with that line of argument as these witnesses come forward today.
Okay. So I agree it doesn't go to the Bowdoin defense. It's essentially foundation for a missing witness argument and instruction. The witnesses are here, they're not really missing, and I don't know that I would be inclined to give a missing witness instruction in any event. But that doesn't preclude the defendant from making the argument that certain witnesses weren't called, basically to make an argument that's something short of that. I think it's Commonwealth v. Pena. I'd have to look at the case again, but that's my recollection. But that is short of a missing witness argument where you argue that the jury can infer something about the testimony. Obviously, if the witnesses are called, the jury doesn't have to infer what their testimony would be because they will hear their testimony. So I would permit questions, because I think these witnesses are not witnesses who are going to be terribly friendly to the defense.
That's a fair statement, Judge.
And so some questions along the lines of whether they were, whether they are biased. And so their contact or communication with the DA's office versus the defense, I think, is fair game. But whether they were subpoenaed, again, I think that is implied, and you can still make the argument that you called them versus the Commonwealth, and I think it's also obvious that they were available if you were able to secure their presence, that the Commonwealth would have been able to secure their presence. But I wouldn't permit questions as specific as whether they were available to be subpoenaed by the Commonwealth. Again, I think that may all kind of just be obvious to the jury in any event, and I will permit defense to make arguments about what evidence was presented, given that the Commonwealth has the burden of proof, without going as far as making a missing witness argument for reasons I've stated. So I guess we'll just sort of see how this goes, but that is at least my thinking
Yes, Your Honor.
at this point.
Thank you, Your Honor.
So Judge, just in terms of lineup, I plan on calling, I would call him Canoa, I plan on calling Daniel McKinney first, and then Dr. Lippman right after.
Okay.
The next most important witness for us would be Dr. Arden, who will be landing at noontime and probably won't be available until about 2. I don't know how long the cross-examination of Dr. Lippman is going to be, but we'll have to regroup after that and figure out where we are, because I certainly don't want to waste the jury's time at all. But I would also be asking the court to do a colloquy with my client regarding her decision not to testify in this case at some point before the end of the proceedings.
And just keep in mind that if there's a gap in terms of witness availability, I always say the same thing. I always tell the jury that it's my fault, that I have something I have to attend to. I will give you the time you need.
Thank you, Your Honor. I appreciate that.
Your Honor, if I could also just to round out the scheduling for today, that we, at the defense's subpoenas and requests, there are 5 members of the state police currently waiting outside to be called today. They're William Medina, William McMillan, Peter Holman, John Riley, and Geraldine Bresnahan. So we should have plenty of witnesses to fill any gaps today. Or if they're not being reached today, I would ask that whenever that becomes apparent, they be released so they can return to their other duties, which they're unable to do.
Absolutely, Judge. And had they called me and not called the district attorney's office, I would have been able to fit them in my schedule better, but they didn't. Instead, they went directly to the district attorney's office. They didn't call me at all.
It's okay. So, again, I'm not going to force you to call witnesses in any particular order or
Thank you.
at any particular time, and I hope that you will take their schedules into consideration, and I sense that you will, but you have your priorities, so
I do, Judge.
do what you need to do.
Thank you.
Yes, we're ready for the jury.
Judge, can I just check and make sure my first witness is out there?
Sure.
Thank you.
For all right.
just
Oh, I'm sorry.
a moment. It's okay.
Getting a little excited about doing this. I'll sit.
Good morning. Members of the jury. It will come as no surprise when I ask you if anyone had any difficulty following the instructions that I gave you before we broke yesterday and that I've been giving you all along, which are to refrain from discussing this case with anyone, including each other, refrain from any form of outside research or investigation concerning this case, avoid contact or avoiding contact with any of the participants in this matter, and avoiding all media accounts concerning this case. If anyone had any difficulty following those instructions, please raise your hand, and I see no response.
Judge Mayer?
You may.
Thank you. The defense would call Daniel McKinney, please, as its first witness.
Legislation. Please stand here, fix the court, please, you ready to be sworn?
You solemnly swear the evidence which you shall give to the court and jury in the matter now in hearing shall be the truth, the whole truth, and nothing but the truth, so help you God, or do so. Thank you, sir. Watch your step.
Thank you.
Good morning.
Good morning.
In a loud, clear voice, can you please say your name, spelling your first and last name for the record?
Daniel McKinney, Daniel McKenney.
And what do you do for a living, Mr. McKinney?
Firefighter, paramedic, Ludlow Fire Department.
With what fire department?
Ludlow Fire Department.
And how long have you been a firefighter, paramedic with the Ludlow Fire Department?
18 years.
Okay. And what are some of your duties and responsibilities as a firefighter in the Ludlow Fire Department?
Me in particular, I've been recently promoted to a lieutenant. I'm second in charge of our crew, which is a crew of 9. So I'm in charge of kind of training, preparing our crew for whatever we may have to respond to, whether that's a medical call or a fire call related stuff. On top of that, I do respond as a paramedic with the ambulance, and any kind of fires, obviously, I'm responding to with the crew, and in charge of a small team at a fire if we have a fire, which is an internal, kind of internal operations in a fire.
And do you have a certain, back in 2010, and specifically in March of 2010, did you have a certain set schedule of days on and days off?
We did, yes.
And can you tell the jury what that set schedule was back in March of 2010?
So back then we did 4 days, excuse me, two 10-hour days, which consisted of 8 a.m. to 6 p.m. We had our next two work days were nights. We went in at 6 p.m., worked overnight, and got out at 8 a.m. the next day. So four full shifts, 2 10-hour shifts, 2 14-hour shifts, back to back, 4 in a row.
Okay. And I'm going to ask you, do you know Cara Rintala?
I do.
And he's here in the courtroom?
I do.
And can you tell the jury how you know Cara Rintala?
I know her from AMR prior to my employment at the Ludlow Fire Department as a EMT, and following my becoming a firefighter, that's basically how I got to know her as well as I did back then.
Okay.
More so in the fire department.
In 2010, was she part of your crew?
She was.
Okay. And when you say crew, can you explain to the jury what that? I think we all think we know, but tell the jury what that means.
So we have 4 crews in the Ludlow Fire Department, which consists of, back then they consisted of a captain, and back then it was 6 or 7 firefighters, paramedics on each crew. Now that's kind of increased. We have lieutenants, captains, and firefighters and paramedics underneath the lieutenants and captains. Back then it was just a captain and 5 or 6, maybe 7 firefighters underneath each captain.
Okay. And can you tell me, back in March of 2010, was there a way to get, or was there an opportunity for overtime at the fire department?
Yes.
And can you tell the jury about the opportunity for overtime?
So we had two particular ways that you could obtain overtime. It was either a shift overtime, which you were asked in advance, usually at least 24 hours in advance, and you could either accept it or refuse it. Another option for overtime that we had, which happened more often, was a daily callback, is what we called it. If the ambulance goes out, we're taking 2 people out of the station that goes out on that ambulance, and they're at the hospital for about an hour and a half. So per our agreement with the town and our contract, we had a set number of in-house personnel that we have to maintain, which we'll say it was 6. I think it was 6 back then. So ambulance goes out on a medical call, two firefighters, paramedics are out of the building, out of town for an hour and a half. We're obligated to call 2 paramedics in the station to cover until those 2 firefighters, paramedics return from the hospital.
And I'm going to ask you, so that you would get a call from the fire department asking, and if you were on the team that wasn't actively working that day,
Right.
and there needed to be coverage, you would get a call from the fire department
Yes.
to come in.
Yes.
Okay. And if you answered that call, am I right in saying that you would be sort of on the hook for 3 hours?
You're on the hook for 3
Can
hours.
you tell the jury what that's all about?
So a callback in itself is a 3-hour obligation. If you accept that callback, that particular piece of overtime, it's a 3-hour piece of time, if you will.
So even if you went in and you only needed for 10 minutes, you still were on the hook for 3 hours because you answered the phone.
That's right. That's right.
Okay.
Yes.
And so, if you didn't have the opportunity to be available for 3 hours, would you, as a firefighter back then, simply just not answer the call?
Right. We would not. If the phone rang, we knew it. You know why the phone is ringing. It happened several times a day. Sometimes more than others. It fluctuates, but 9 out of 10 times you know why that phone's ringing. They need coverage for an ambulance call, and if you're not available, you just don't answer.
And was that a pretty common occurrence back in March of 2010? If you didn't have that 3-hour window, you just wouldn't answer the call?
Very common. Yes.
And are you aware of how your overtime was accounted for when you went in, when you did answer a call? If you did answer a call that day, are you aware of how your overtime would be accounted for?
In terms of
Was there a slip that somebody signed off on?
yes, yeah.
Okay.
You'd come in, you'd have a slip waiting on the desk, and you have to write we had to write the time that we showed up at the station, that we got there for that particular overtime callback, which is usually within 20 minutes of that ambulance call going out. We had to be in the station within about 20 minutes of that call going out.
And if you only were needed, let's just say, for 20 minutes, did you have to stay at the station, or could you go home, but you were still on?
You can go home.
You could go home,
You
okay.
can go home.
So within that 3 hours, you could go home, but you understood that for that 3 hours, if anyone else went out, you had already answered, so you had to go back.
You can go back. You don't have to.
Okay, so tell us about that.
So you come in to do a callback. The ambulance is on scene at a medical call. Okay, you're there to cover for that ambulance crew of 2. Okay, it turns into, for whatever reason, a non-transport. Happens a lot. There's refusals. Sometimes it's just a lift assist. We help people get up and back into bed, that type of thing, and it's not a transport. So the ambulance crew is coming back to the station probably within a half an hour of that call going out. So now we don't need that coverage that we called out for. So that person can leave and go home. By being on the hook for 3 hours, you have somewhat said you're available for 3 hours. If you're released because that ambulance came back early and it wasn't a transport, you're now out of the station. If another call, excuse me, if another call comes in within 3 hours, they'll call you back, that person that's on the hook, back first. You're still on the hook for that. If for whatever reason you're not available to come back for whatever reason after that, you cannot answer, you don't have to answer that secondary call to come back in. And then we'll just move on with the list and call someone else in. So and essentially your 3 hour on the hook ends whenever that second call goes back out and you don't answer. If that makes sense.
I ask you to take a look at a document that I'm placing in front of you. Do you recognize that as the overtime slip that would get filled out regularly when you get called in for overtime?
Yes.
And that particular slip, does that indicate that Cara Rintala was called in on March 29th, 2010?
Yes, it does.
And at what time?
9 o'clock, 9:47 a.m.
And what time was she released?
She was released at 10:25.
So would that be an example of one of those calls where you may just have to lift someone, or you may have to just do something very quickly?
Yes.
And then you could return home, is that right?
Yes.
That doesn't introduce that.
Moving to introduce both pages. Or
Just the first page.
I have no objection to the first page, John.
Exhibit 164.
Now, if you had already gone in once picked up that phone and answered and agreed to go in, how common was it to, after that 3 hour period expired, to pick up the phone again?
Objection.
Well, let me ask a better question, Judge. That probably wasn't a great question. So in your experience as a firefighter, working with your squad back in March of 2010, was it common for firefighters, especially if they had already answered one call, to not pick up the call for a second or a third time that they may have been called that day?
Objection. In terms of all
All
firefighters
firefighters.
versus himself or his.
I'm going to sustain it to 4, but if you could just ask the
In your experience, sir,
question.
in your experience as you were employed in working for the fire department, was it your experience that if you had already picked up a call that morning, that you would routinely not pick up another call if you couldn't go in and commit to another 3 hours?
If I could not,
Yes,
I would not. No,
you would not pick up that
I
call?
would not pick up that.
And that was pretty common for you back in March of 2010 when you were working
Yes.
for the same the firefighter, the same department that Cara Rintala was working for.
Yes.
Is that right?
Yes.
I don't have any further questions. Thank you.
Good morning, Mr. McKinney.
Good morning.
The exhibit that was just admitted, I think you indicated that the defendant was called in at 9:47 a.m. in the morning,
Yes, ma'am.
and that she was released at 10:25.
Yes.
So this would have been one of those incidents where you're on the hook based on answering the call for 3 hours, correct?
Yes, ma'am.
But she was not required to stay the 3 hours?
No,
Would she have been paid the 3 hours?
she would have.
Okay.
She would have. If there wasn't another call that came in following that within the 3 hours, and her 3 hours elapsed, that 3 hours elapsed, and there wasn't another call prior to that 3 hours that she didn't respond to.
Okay.
If there was another call after this one within that 3 hours and she didn't answer that return call, she would stop getting paid at whatever time that was.
Okay. But if there wasn't another call within those 3 hours, she would have been paid for the full 3.
She would have.
And if I'm doing my math right, 9:47 a.m. to 10:25 is about 38 minutes, correct?
Yeah.
So is it fair to say that it could be potentially lucrative to you as a firefighter or paramedic to answer such a call, to know you might get paid for 3 hours, but you might not have to actually work the full 3?
Yeah, I guess in general terms, but prior to going in and accepting that any particular call, you're unaware of what the call is. So you don't know whether you have no idea if it's gonna be more of a lift assist or refusal versus a transport.
So there's a risk, right?
There is.
You don't know what you're getting into exactly.
You don't.
You're definitely committing that you have to be available for the next 3 hours, right?
Yes.
But
Yes.
it's not an uncommon experience that you be called in and released much quicker than the 3 hours and still get paid for the 3, correct?
No,
No,
it's not an uncommon.
okay. Now, would you agree with me, Mr. McKinney, that being a firefighter paramedic, as you are, requires a certain amount of strength or physical fitness to do
Yes.
that job?
Yes,
Are there minimum physical requirements that you have to both have initially and then maintain to be able to stay employed as a firefighter or paramedic?
for us, the Ludlow Fire Department, it's just an initial hiring requirement in
Okay.
terms of a physical ability test.
So you're not required to maintain any sort of physical fitness or ability to do your job in the years that you're doing it?
No,
What would happen if you weren't able to lift up patients or lift up equipment?
typically that doesn't happen. We don't have members that aren't able to do their job. If that were the case, I'm sure that there would be some kind of something put in place in terms of getting someone back into the shape to be able to do the job. However, that hasn't been an issue or a problem for us, particularly Ludlow Fire
So
Department.
you would agree that being a firefighter paramedic requires a certain amount of strength, correct?
Sure,
And that there are certain tests or physical minimums you need to meet as a firefighter or paramedic, correct? You just have to answer for the record.
yes,
Okay. And would that include such things as carrying the gear, handling equipment, maybe using the jaws of life, lifting patients, lifting stretchers?
yes,
And if you're fully geared up as a firefighter, would you agree that your equipment is approximately 60 pounds that you have to be able to carry on your body to do that job?
yes.
Now, during the time that you worked with the defendant, how many years was that in the Ludlow Fire Department or AMR?
I believe 5 years.
5 years?
Ludlow Fire Department, 5 years.
Okay. And you were on the same crew with her at times, correct?
Yes.
And so you were able to observe her at scenes doing all the things that we just referenced?
Yes,
Did you ever see her struggling to be able to do the physical requirements of this job?
no,
Did you ever see her struggling in terms of carrying 60 pounds of equipment?
no,
Did you ever see her struggling to lift up bodies?
no,
Would you agree with me that in March of 2010, the defendant was very fit?
yes,
Do you remember a couple of weeks before Annamarie's death, running in the St. Patrick's Day road race in Holyoke?
I do, yes,
And this would have been in March of 2010?
yes,
Do you remember the defendant also running in that road race?
yes, I do.
Mr. McKinney, I'm just going to show you a photograph there. If you could take a look at it, please. Do you recognize that?
I do,
And do you recognize that as a photograph taken of the defendant running the Holyoke road race in March of 2010?
it looks it, yes,
Okay.
yes.
You're going to ask that this be marked as the next exhibit?
No objection, Your Honor.
165.
Did you run any other road races with the defendant during your time that you worked with her?
Not that I recall, no.
Okay. Do you remember the Holyoke road race? It's a 10K?
It's a 10K.
Okay. Thank you. I have no further questions. Thank you, Mr. McKinney.
Mr. McKinney, I'm gonna. Yep. I'm gonna ask you to look at these two photographs regarding the road race and tell me if you recognize what's depicted in them.
And the first one is myself and Cara standing. I believe this is, it's either before or after the race, I'm not sure.
The St. Patrick's Day race?
Yes, St.
Okay.
Patrick's Day race.
And the second one is what?
The second one is our crew A few of us from the same crew and a couple from other crews, just members of the Ludlow Fire Department.
Okay.
It looks like it's after the race.
And you guys ran as a group, is that,
Yeah.
you had like a
yes.
team, all
Yeah.
had shirts?
Kind of, yeah,
Okay.
yes.
Judge, I move to introduce those two exhibits.
No objection.
166 and 167.
So just so we're clear, I'm sure this got shown to the jury. This photograph, exhibit 165, that's the picture of Cara Rintala running the race, is that right?
Yes, ma'am.
And this picture is, and this is exhibit 166, is you either before or after the race, is that right?
Yes, ma'am.
And this final exhibit, 167, this is you and your crew. It looks like after the race, because people seem to have drinks in their hand.
Right.
Is that fair to say?
Yes.
I don't have any further questions, thank you.
Nothing further. Thank you.
You want to step down? Thank you.
The defense would call Dr. Jennifer Lippman.
This way.
Please raise your right hand.
That over yours?
Do you solemnly swear the evidence which you shall give to the court and jury in the matter now in hearing should be the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
Thank you.
Dr. Lippman, in a loud, clear voice, could you please say your first name and your last name and spell it for the jury?
Jennifer Lipman, L-I-P, like Peter, M-A-N.
And what do you do for a living, Dr. Lippman?
I'm a pathologist who recently retired from hospital work, and I am now doing consulting work and private autopsies.
Okay, can you tell the jury what's a private autopsy?
A private autopsy is an autopsy that a family requests because it is not mandated by the state, so if they want an autopsy on someone who dies under circumstances that the medical examiner is not interested in pursuing, then they still want an autopsy. They ask me to do it.
Okay. And could you tell the jury a little bit about your educational background?
I have a bachelor's degree in biology from Haverford College in Pennsylvania. I have a medical degree from Temple University School of Medicine in Philadelphia. And I did my residency in anatomic and clinical pathology at the Deaconess Hospital in Boston. And I did a fellowship in gastrointestinal pathology in Boston at the Deaconess Hospital. And then I did an additional fellowship in forensic pathology at the Boston Medical Examiner's Office.
Okay. And in starting with college, you would have gotten out of college somewhere around 1984, is that right?
That's right.
In med school in 1991, is that right?
Yes.
and then your residency from 91 to 95 at Harvard Medical School, is that right?
Yeah, the Deaconess Hospital
Okay.
affiliated.
And then, and your clinical fellowship at Harvard Medical School, Deaconess Hospital, the surgical pathology fellow would have been from 95 to 96, is that right?
That's right.
And then your forensic pathology fellow at Boston University, would that have been from 96 to 97?
Yes.
And then, after 97, did you start working as a forensic pathologist anywhere?
Yes, at the medical examiner's office
In what
in
state?
Massachusetts.
Okay, and what was your title starting in 1997 when you first began working for the medical examiner's office in Massachusetts?
After my fellowship,
After your fellowship, yes.
I think they called me an assistant medical examiner.
And what duties and responsibilities did you have as an assistant medical examiner?
Assistant medical examiners do the autopsies and write the reports for the cases that come into the office. There's a chief medical examiner who oversees the office, and then I guess there's a deputy chief who takes over in case that chief is out, and then the rest of us are assistant medical examiners who do the cases.
Okay. And I forgot to ask you before, are you board certified?
Yes.
And where are you, what certifications do you hold?
I'm board certified in anatomic and clinical pathology and forensic pathology.
Okay. And in terms of your initial work as an assistant medical examiner at the Massachusetts medical examiner's office, at some point were you promoted?
Well, I wasn't promoted, but I was, they opened the Worcester office, which had been closed, and they sent me to the Worcester office to be the medical examiner for the county of Worcester, which it wasn't really a designation, it was just like my catchment area was the county of Worcester.
Okay. And what did you do when you were a medical examiner for the county of Worcester?
Well, I was in the UMass Medical Center morgue, and I did all the autopsies that came into the medical examiner's office from that county, and I served on the Child Fatality Review Board, and I was kind of the only medical examiner in the county, so I did whatever the county needed me to do, and I testified in court and went to scenes and wrote my own death certificates. I didn't have a secretary, so it was a very busy job.
Okay. And in your capacity, I think you just started to say, in your capacity as a medical examiner for the state of Massachusetts, had you testified in courts on behalf of the Commonwealth as a medical examiner during that time period?
Yes.
On how many occasions would you estimate?
I can't even guess. All the homicides, the motor vehicle homicides, I don't know. I didn't keep track. It was a long time ago too, so I don't remember. It was way more than 20, less than 100.
Okay. Of actual court appearances, court testimony, is that right?
Yes.
Okay. And during that time period, you were testifying on behalf of the Commonwealth, is that right?
That's right. And after I left, because there were several homicide cases that, it takes a long time for them to come up to trial, so I left the office in 2003, and some of those cases came up years later.
Okay. And when you just said you left the medical examiner's office in 2003, where did you go from there, from the medical examiner's office?
I was a pathologist in a hospital at Lawrence Memorial and Melrose Wakefield hospitals. It was a pathology group that ran the pathology departments in both of those hospitals, and I worked in both of those hospitals.
Okay. And then in 2014, did you take another job?
Yes.
And what was that?
In 2014, I went to the Beverly Hospital, working for the Beverly Pathology Associates group that ran the pathology department at Beverly Hospital.
Okay. And as a pathologist in these various places, Melrose, Wakefield, Lawrence Memorial, Beverly Hospital, would you actually do the autopsies, or would you consult?
At the hospitals?
Yes.
At Lawrence Memorial and Melrose Hospital, I was the only one that liked to do autopsies. Most hospital pathologists don't want to do autopsies, so when I came there, they were all like, yeah. So I did most of those autopsies. There weren't that many, though. I mean, hospital autopsies aren't as common as they used to be, especially in a community hospital. And at Beverly Hospital, there were hardly any. I don't remember. Maybe I did one adult autopsy. Most of the autopsies at Beverly Hospital were on stillborns.
Okay. And you then, you were doing some consulting work, is that right?
Yes.
Okay, and so tell the jury about your consulting work.
Well, since I left the medical examiner's office, I've been doing the private autopsies and some homicide defense consulting work, depending on how much time I had to do it.
Okay. And in this case, you said you retired when?
Last summer.
Okay. And in this case, can you tell the jury whether or not you're receiving any funds from the Committee for Public Counsel Services to be here today and testify?
Yes.
And do you know even what the rate is per hour that, well, first of all, do you understand the Committee for Public Counsel Services to be the agency that deals with indigent?
Objection, Your Honor. Relevance.
Overruled.
Do you understand the Committee for Public Counsel Services to be the agency in Massachusetts that deals with indigent defendants?
Yes.
And in this case, did you agree to work at the Committee for Public Counsel Services rates on this case?
Yes.
And do you know what that rate is?
I know they increased it to, I think it's approximately $300 an hour.
Okay. And is that below what you would normally charge your private clients?
Yes.
Significantly below?
Yes.
Okay. And in this case, you agreed to work for that rate on behalf of what was my request for you to come and evaluate this case. Is that fair to say?
Yes.
Okay. And in this case, were you given, so you and I had a conversation, and then did you review some documents?
Yes.
Do you remember specifically what you reviewed? Well, let me ask you, in your list of reviewing them, did you review the autopsy in this case?
The report of the autopsy,
Yes.
yes.
Did you review crime scene photos?
Yes.
Did you, and were you asked a specific question with respect to your consulting in this case, specifically whether or not you could rule out the possibility of, well, tell me what your understanding of the question you were asked to answer, the reason that you were consulted.
My understanding of the reason I was consulted was to answer the question, could she have died before 3 o'clock or after 3 o'clock?
Okay. So you were asked specifically, when you say could she, you were asked specifically in this case to evaluate whether or not it was possible for Annamarie Cochrane-Rintala to have been dead prior to 3 o'clock or after 3 o'clock. Was that your focus in evaluating the information in this case?
Yes. Specifically, more accurately, would it be possible that she died after 3 o'clock? So, like, 3 o'clock was kind of a dividing line, and whether I could say that she was dead before 3 o'clock or after 3 o'clock.
Okay. And when you were asked that information, the 3 o'clock information, did you do some evaluations to determine, in your opinion, whether or not that 3 o'clock timeline was a reasonable estimation as to the death of Annamarie Rintala?
I reviewed the autopsy report and the crime scene photographs and the statements of people who evaluated her at the scene.
Okay. And in this case, Dr. Littman, you became aware at some point of a call that Cooper McGarrian made to Dr. Richmond asking.
Objection.
Who are you? let me ask you again before the break. I was asking you a question about your review of Dr. Richmond's answer to Trooper McGarion's hypothetical on the night of March 29, 2010. If a body could be cold as ice and stiff as a board, could it have been dead for only 3 to 4 hours? Do you remember that being part of what you evaluated in this case?
Yes.
Okay. And do you remember Dr. Richmond's answer being no, it would be closer to 6 to 8?
Yes.
Okay. And in this case, that 6 to 8 answer that Dr. Richmond gave, does it reflect the mean onset of well-developed rigor in the average person?
It's the generally accepted average time that rigor is present.
Okay.
Well, rigor is present. It's not an absolute, but when you're reading the textbooks or reading literature, there's an about. So it's about 6 to 8 hours where rigor becomes full.
Okay. So, but the 6 to 8 hours is of the average person, meaning that a person who hasn't been engaged in a vigorous or violent struggle before death and is of average size. Is that?
Hold on. So sustained as to the form?
Okay. Let me ask you. When you say 6 to 8 is the average, does that take into consideration whether or not someone has been engaged in a violent struggle?
It's the average of all comers.
What does that mean?
It means like everybody. If you took all of the cases and threw them all together, that would be the average. It doesn't specify a certain any individual circumstance. It's the average.
Okay. And in this case, in your review of the evidence, did you find evidence in this case of a struggle prior to Annamarie Rintala's death?
Yes.
And tell the jury what you relied on to determine if there was a struggle.
The autopsy report and the photographs from the autopsy that show that she had petechial hemorrhages in her eyes and on her face, and she had trauma to her neck, and she had abrasions on her neck that would be consistent with a struggle to remove something from around her neck.
And is it your opinion, Dr. Littman, that in order to engage in a struggle like that and leave the marks behind that were on Annamarie Rintala's body, that she would have been awake and struggling during some period of time
Yes.
prior to her death?
Yes.
Now, again, with the 6 to 8 hours in terms of the average of everybody in the world, that number doesn't take, well, let me ask you this. If you take that 6 to 8 of everybody in the world and you add that fact that you found, which was this vigorous or violent struggle immediately before death, is it correct that the 6 to 8 hours would move to the left, the bell curve would move to the left on the time it would take to get to full rigor?
Objection, leading.
Sustained as to the form?
Sure. So can you tell the jury, when you talked about that 6 to 8 as being the average of everybody, when you add in the fact that you found in this case that Annamarie Rintala had been engaged in a struggle, in a vigorous struggle, immediately before her death, what, if anything, does that do to that 6 to 8 hour average? Does it move it to the left?
So a violent struggle depletes the glycogen in the muscles, and the process of rigor is speeded up by that depletion. So, I can't tell you how far it would change it, and that would all depend. There are so many variables, and it's dependent on each individual circumstance, but it would make the average, if you took out just the people in a violent struggle, the average would be lower than the average of everybody.
So lower than 6 to 8.
Yes,
Can't rule out 3 to 4.
right.
So can't rule out 3 to 4 hours based on the violent struggle. Is that right?
Well, can't rule out in my mind, you can't rule out 3 to 4 in any circumstance because there are outliers and the curve extends pretty far. But the likelihood of 3 to 4 hours increases with the violent struggle. So it makes it less of an outlier, so to speak, of the amount of time it takes for rigor. There have been descriptions of rigor happening very quickly in people who aren't in a violent struggle as well. It's just that the violent struggle is something that is recognized as depleting the glycogen, and it would therefore shift the onset and development of rigor to a quicker time period.
Okay. And in your review of the materials provided in this case, did you also, was there anything else that you reviewed that would increase the rate at which rigor appears?
Well, the cooling of the body would slow down the development of rigor, and she was kind of a stout person who would be a little bit insulated from cooling quickly. So that would also help to speed up the rigor because it would decrease the rate at which her body would cool off.
Okay, so having a BMI of 33, does that have any effect, increase or decrease the rate at which rigor appears, in your opinion?
Insofar as it would affect the rate of her cooling,
Okay.
I would say that it would help to keep her body warmer, which would speed up the rate of rigor. But I think the struggle is more of a significant contributor to making that process faster.
Okay. And in the review of the documents that you reviewed in this case, when Dr. Richmond performed the autopsy in this case with Cooper Megarian, should she have been aware at that point, based on the evaluation of the body and the crime scene evidence of the violent, of the struggle, and the abrasions on the neck that were consistent with struggling to get someone's hands off your neck?
Objection.
Basis.
Asking this witness to opine as to what someone else should have been aware of. Speculation. Foundation.
So you reviewed Dr. Richmond's report in this case, is that right?
Yes,
And you know she conducted the autopsy, is that right?
yes,
And in this case, when she conducted the autopsy, I think your testimony already was that there was evidence of struggle within the autopsy itself based on the bruising and the marks on the neck. Is that right?
yes.
Okay. And based on those findings, when Dr. Richmond submitted her autopsy report in this case, is it fair to say, well, do you believe, in your opinion, that Dr. Richmond did not consider, in analyzing the time of death, the manual strangulation that indicated a violent struggle, or the BMI of over 33? Did you see any evidence that she considered that in the report that she generated?
Objection.
Well, it seems like there's a couple questions in there now, so I'm going to sustain the objection as to form.
Okay. So let me ask you again. When you reviewed Dr. Richmond's report in this case, and the crime scene photos, did you come to an opinion as to whether or not Dr. Richmond learned during her review that there was manual strangulation and abrasions on the neck consistent with someone pulling on the neck?
Objection.
Counsel sidebar.
it up, let me ask again. You've seen the testimony of Dr. Richmond, is that right?
Yes.
Is it fair to say that she testified that sometime in May of 2010, she went to a meeting with Trooper McGarrian where she determined her time of death?
Yes.
And at that point, based on her testimony, do you know whether or not she considered, at least in her testimony, the evidence of violent struggle with a BMI of over 33 in her testimony?
She testified as to the cause of death
The strangulation.
being a strangulation.
But then you're also aware she testified as to the time of death in that 6 to 8 range, is that right?
Yes.
Okay. And I guess the question that I keep asking that apparently I'm not asking well, is that 6 to 8, at least at that meeting in May of 2010, in your review, didn't consider violent struggle or BMI over 33, is that right?
Well, it was the same time frame that she gave when she was just faced with a cold, stiff body. So,
And
without...
before we stop you there, when you say cold, stiff body, can you tell the jury, do you put any emphasis in your evaluation on the coldness of the body when you're asked to determine a range of time of death?
You mean just to touch the body?
Yes.
Well, yes, in terms of, like, did it happen 2 seconds ago? You know, if the body feels cold, it didn't die within the last minute. But a dead person feels unusually cold to a person who's alive. I mean, so cold is a relative thing. If you say somebody's cold as ice, does that really mean cold as ice? Because cold as ice is 32 degrees or less, and does that mean that body feels like it's 32 degrees? Well, it's kind of a term, right? You say cold as ice. I'm cold as ice when you're outside. So cold as ice doesn't mean cold as ice. It means it feels cold. And a dead person will feel cold because they're not 98.6 degrees, and you're not used to touching people who don't feel like they're at body temperature.
So is what you're saying that it's not a reliable indication of rigor?
Objection.
Sustained.
Is it a reliable indication of rigor? Just the feeling of being cold to someone who's not a forensic pathologist?
A reliable indication of rigor?
Yes.
Well, rigor is the stiffness. So is it a reliable indication of how long they've been dead? More than a minute or two? I mean, because it's not a reliable statement. Cold as ice is not very scientific.
Okay, so let me get back to the Trooper McGarrian hypothetical. In your review of the testimony in this case, in your review of Dr. Richmond's, specifically Dr. Richmond's testimony, understanding the violent struggle in the BMI of over 33, should the window of time of death have been expanded when you added those factors in?
Well, yes, because the violent struggle particularly will decrease the time period necessary to develop rigor. It's one of the things that is known to decrease the time. So if the time is 6 to 8 without knowing that, if you know that, then naturally the time should be lowered because you know there's a factor that lowers the time that wasn't considered with the average that was given without knowing that information.
Okay.
That makes any sense.
And
That was
what-
kind of convoluted.
So in determining the low end of the time of death window in light of the evidence of violent struggle immediately before death and a BMI of 33, can you rule out the 3 to 4 hours that was in the original hypothetical from Trooper McGarrian, if you add in the factors of struggle immediately before death and BMI of 33, can you rule out 3 to 4 hours?
No.
And could that number, can you rule out 2 to 3 hours?
Well, ruling out makes something can't happen. And there are cases where rigor has been described within minutes in someone that doesn't have any recognizable reason for that to happen. So to say, can you rule out 2 to 3 hours? No, you can't rule it out. It's not incredibly likely, but it can't be ruled out. 3 to 4 hours becomes much more reasonable and less of an outlier when you have a violent struggle. So the 2 to 3, I think, in the realm that yes, it could happen, rarely, but the 3 to 4 is more of a reasonable time period for someone who's been in a violent struggle.
So so are you saying that adding in the information of a violent struggle and a BMI of 33, that you can't rule out 3 to 4 hours, but not just that you can't rule it out, that becomes more of an inlier than an outlier? Am I understanding that correctly?
Yes, it becomes less unlikely.
Okay. And is that because that 6 to 8 hours doesn't include information of the struggle or the BMI of 33? Is that right?
Yes, the 6 to 8 being an average of everyone. Of course, some of those people are people with violent struggle. They are people that have this circumstance, but it's not selected for. And if you select for that circumstance, then the time is going to be less for the onset of rigor. It's going to shift from the 6 to 8.
And what factors in this case were relevant to a determination of time of death, assuming everyone knows you can't do it exactly? But what factors were relevant here in your examination? Was rigor mortis relevant?
Yes.
Was vigorous struggle immediately before death relevant?
Yes.
Was BMI greater than 33 relevant?
Less, but somewhat, yes.
Okay. And if you were to plot a data set of people with well-developed rigor, all of whom had been engaged in violent struggle and had a BMI of over 33, would you expect the mean of that group, the high point of the bell curve, to be less than 6 to 8 hours?
Objection.
Overruled.
You can answer the question, Dr. Littman. You had all of those factors, not just ice cold and stiff as a board. But if you have the factors that there was rigor mortis, there was a violent struggle before death, and there was a BMI of 33. If you were to plot a data set of those people with well-developed rigor, all of whom engaged in a violent struggle and had a BMI of over 33, would you expect the mean in that group, the high point of the bell curve, to be less than 6 to 8 hours?
Yes, if the high point of the bell curve is 6 to 8 hours for all comers, then it's going to be less if you select out the people who have a factor that lowers the time frame for the onset and development of rigor. So yes, it would shift lower than the average for all comers.
Yes, I Your Honor. And just going to shift to another topic at this point, Dr. Littman, and that is you received some autopsy photos in
Yes.
this case that you reviewed, is that right?
Yes, I did.
Okay, and in reviewing those autopsy photos, did you, in reviewing the autopsy itself, did you come to an opinion as to the trauma to the victim's head and whether or not the victim would have been awake and alert during that time period?
During the time period of this, of what?
Of the struggle.
Of the struggle. Yeah, she did have significant head trauma. She had lacerations. She had hemorrhage surrounding those lacerations, which indicates that she was alive when those lacerations happened. They didn't happen post-mortem. And there was no injury to the skull itself. It was skin and subcutaneous tissue. The scalp was injured. The skull itself was not injured, and the brain itself was not injured. So there was nothing to say that she was unconscious. And the fact that she did, it appears that she attempted to remove whatever was around her neck, also indicates that she was not unconscious at the time that she was strangled.
Okay. And in this case, did you come to an opinion as to whether or not, based on everything that you reviewed, that you could rule out the possibility that Annamarie Rintala died after 3 o'clock?
Can you repeat
Sure.
that?
In your opinion, when you reviewed everything, you were asked, you told us at the beginning, you were asked to try to determine whether or not 3 o'clock was a possibility, whether or not Annamarie Rintala could have died after 3 o'clock. Based on everything you reviewed, do you have an opinion as to whether or not you could rule out Annamarie Rintala dying after 3 o'clock?
I could not rule that out.
Okay. And is that based on the evidence of struggle, the BMI of 33, and the rigor mortis that was present?
Yes, and also that rigor mortis is not the most reliable way to tell how long someone's been dead anyway. So it's not something to be relied on solely as the time of death.
And is that a pretty common statement within the forensic pathology community?
Yes.
And so what do you understand the forensic pathology community to say about rigor mortis in determining time of death?
That it's okay to look at it to see very broad possible times and ranges, but it's not something to be specific about the time of death with, and it's not something to be 100% sure about what it's even showing you in the range, because the range is so huge. There are descriptions of people in full rigor, within an hour. There are descriptions of people that don't go into full rigor ever. There are, so it's not something to be relied upon. It's something to be used in the context of a lot of other things that you can evaluate, the body temperature, a lot of times circumstances that have nothing to do, with the actual body, but more about when did someone see them, when did they, has their mail been piling up for a week, was there hot food on the stove that was, still present and not completely burned up, things like that. So it's a part of the puzzle, but it's not something that is to be relied upon solely as a determinant of the possible time of death.
And let me ask a question based on your answer. When you were talking about possible time of death, in some of the things you rely on, do you sometimes rely on statements of people who were in the house as to when they last saw somebody alive?
Yes.
And would you rely and consider that statement if there wasn't evidence that that person was on video somewhere else, say at the time that they say that they talked to the victim?
I'm sorry, what?
Sure. So when you're considering that statement at 3 o'clock, would you consider it that 3 o'clock statement, as long as there wasn't evidence that whoever said 3 o'clock was somewhere else at the time, physical evidence that they were somewhere else at the time? You consider that 3 o'clock, right?
Yes.
And if there was evidence that someone said 3 o'clock and their phone was in a different state, you might discount that evidence at 3 o'clock. Is that right?
Unless someone else had their phone. Yes.
That's a good point. But in this case, you didn't see any evidence to discount the information that someone had spoken to Annamarie Rintala at 3 o'clock. There was nothing in the file to discount that evidence. Is that right?
Nothing that I saw.
And that's normally something that would be considered, the last person to see the victim alive, right?
Yes.
And that doesn't matter if it's a defendant, or a mother, or a father, it's in the mix and it should get considered, is that right?
Yes, I think it should be considered.
Okay. And in this case, Dr. Littman, were you handed this morning some information regarding prior testimony in 2 different cases, Commonwealth versus Moshier and Commonwealth versus Walker?
Yes.
And is it fair to say Commonwealth versus Walker was your testimony in 1998?
I looked at that this morning for the first time. Yes, if it says 19, I have no memory of that trial. So if it says that's when it was, that's when it was.
All right, and did reviewing this morning refresh your memory at all in
No.
terms of your testimony from 1998?
No.
And with respect to Mark Moshier, the other transcript that you were handed this morning, did you have an opportunity to at least briefly review that this morning?
Very briefly, yes.
And in reviewing that, did that refresh your memory at all about your testimony in the Mark Moshier case that happened in January of 2000, about 23 years ago?
No.
I don't have any further questions.
I see counsel sidebar. All right, we're going to take our morning break. Be a little bit over 20 minutes. I'll ask that you be back for 11:20.
Just make sure she gets it.
Thank you. Yeah.
Superior Court back in session. You may be seated.
Ready?
Yes.
Yes.
Doctor, I just remind you, you're still under oath.
Okay, thank you.
Thank you.
Court all rise.
Yes.
May I proceed, Your Honor?
May.
Thank you. Good morning, Doctor.
Good morning.
My name is Stephen Gagne from the District Attorney's Office, and I have some questions for you this morning. Now, you would agree that as a forensic pathologist, you strive to be both fair and objective, correct?
Correct.
And you'd also agree that an opinion is only as good as the evidence or the data that it's based upon, correct?
Yes.
Now, at the outset of your work in this case, did you request that certain materials be sent to you, or did you just receive whatever the defense attorney sent you?
I did not request materials.
So at no point did you request anything additional or inquire as to whether there were any other materials that may be relevant to your determination, correct?
Correct.
Now, had you wanted or needed additional case materials, you could have requested them, am I right?
I presume I could have requested them.
Okay. Now, let me review some of the materials that you say you were provided in this case. You were provided the Office of the Chief Medical Examiner's, was it the complete file or just the autopsy report?
It was the autopsy report, the notes, the handwritten notes from the autopsy, the toxicology report, and the neuropathology report.
And there was a lot of discussion earlier about Dr. Richmond's report. Do you understand that to be the autopsy report in this case?
Yes.
You're not aware of her authoring any other report, correct?
Correct.
And in that report, you know from your own time with the Office of the Chief Medical Examiner that there are a lot of standard categories or sections in an autopsy report, correct?
Yes.
And time of death is not one of those standard categories, is it?
No.
Okay. You also reviewed crime scene photos?
Yes.
Okay. Do you recall approximately how many photos or when they were taken?
How many photos? I don't remember how many photos. There were some that they were taken at different points.
Okay. You reviewed prior testimony by Dr. Richmond?
Yes.
Do you recall what year or years that was from?
No. I had one document that had references to time of death, but it was from all different trials, so I don't, it's all mixed in my mind, so no, I don't recall which trial, which thing was said.
Were you provided with testimony by a Dr. Thomas Andrew?
Yes.
Were you provided testimony from the two Granby police officers who arrived on the scene that night?
Their names?
Do you happen to recall Gary Poehler, Mark Smith?
Yes.
How about the two paramedics who arrived on scene last night? Did you also receive testimony that they'd given before?
Yes.
And do you happen to recall their names?
Us and
And Nora?
yes.
Okay. So you read all four of those first responders' testimony from a prior proceeding, am I right?
Correct.
Now, did you also review prior testimony from another doctor, Dr. Jonathan Arden?
Yes.
And is there anything else that you can recall off the top of your head that you reviewed in this case that I haven't already covered?
Off the top of my head, no.
So now that we've discussed what materials you reviewed, I'd like to ask you what your understanding was of the task you were hired to do in this case. Am I correct that this morning before the break, Attorney Scapiccio asked you whether you were asked to determine whether or not Annamarie Rintala's death occurred prior to 3 p.m. or after 3 p.m., correct?
Correct.
And you used the term dividing line when describing that 3 p.m. time. Am I right? You used that term?
Yes, yes.
Okay. Now, in going about that task, you considered the observations and descriptions of Anne-Marie's body from the four people who were on scene that night and their first-hand observations. Am I right?
Yes.
And do you recall what Gary Poehler and Mark Smith recall doing or seeing with respect to Anne-Marie's body?
I would have to have those papers in front of me to attribute what each person said, or so I know I read it.
Mm-hmm.
If you prompt me with what they said, I can agree or disagree with whether that's what I understood them to say or not.
Okay, you didn't bring the materials that you were provided in this case with you
No,
to
I
support
don't have
today?
them up here with me.
Do you recall what the two paramedics described seeing or doing with respect to Anne's body?
Again, if you show me the papers, I will tell you if I recall reading that or not. There was a description of, I'm not going to attribute what description was which person because I don't remember who said what off the top of my head. But I know that there was a description of rigor, of stiffness, of coldness.
Okay. So I'm not trying to like pop quiz you about who did what or who saw what, but just generally speaking, what do you recall the first responders describing in terms of what they saw and what they did with Anne's body?
Well, various first responders, and I don't want to attribute anything to any individual because I don't remember which person said what off the top of my head. But one person didn't really touch the body, stood at the bottom of the steps. One person felt for a pulse and also noted that her arms were stiff. And then when they rolled her over, they said that she was very stiff and her body turned as a unit.
Mm-hmm. And one of the officers who was helping to rotate Anne's body actually, do you recall what part of her body he had his hands on?
I don't remember who had their hands where. Someone had their hands on her, I think on her leg or her hip or something, and someone else had their hands on her arms, and she was stiff.
Now, to your knowledge, Dr. Richmond did not go to the scene of the crime, correct?
Correct.
In fact, she didn't see Anne-Marie's body until about 4 days later at the autopsy, am I right?
The first time she saw the body was at the autopsy. That's my understanding.
Okay. Do you recall whether it was 4 days later or more or less?
Well, I think it was a little less because of the time, because she was in the morning. I think she did the autopsy in the morning, if I recall.
Which morning?
Of, again, whatever date it was that she did it, it wasn't a complete additional day after. She was found at night, and the autopsy was performed in the morning a few days later.
Okay.
So
not the next morning?
No.
All right. Now, similarly, Dr. Andrew, whose testimony you reviewed in this case, he did not go to the crime scene, correct?
Correct.
Neither did Dr. Arden, am I right?
Correct.
So none of those other doctors made any of their own observations firsthand about the state of rigor mortis in Anne-Marie's body on the night she was found dead, am I right?
That's right.
Despite that, you chose to read all of their previous testimonies in this case, correct?
Yes.
And you also read a report that was prepared by Dr. Arden?
Yes.
did you also read a report by Dr. Andrew?
Yes,
Now, when the defense attorney sent you these materials, when she sent you the testimony and the reports of other doctors who had their own opinions and who weren't there at the scene themselves, am I correct? You could have said, I'd rather not know what those other people's conclusions are. Correct? You could have said that?
yes,
But you chose not to do that, am I right?
yes,
You did not insulate yourself from the opinions that were held by these other doctors, did you?
insulate myself.
Yes.
I didn't feel like I needed to be insulated from them. I was reading their opinions like I would read other people's opinions. I read the reports from the people who did see the body. I read the same materials that they read before they made their reports, and I read their reports. Are you
You could-
implying that I was influenced by their reports and my reports?
Well, I'm just asking you that you could have put aside their opinions, looked at the raw observations themselves, formed your own independent opinion based upon the data, and then you could have turned and said, now let's see how my opinion matches up with what other people have said. You could have gone about it that way.
Well, I did see the crime scene photos and the information from the first responders prior to reading their reports, but I did read their reports.
Right, the first responders.
No, I'm saying I did see the photographs and the autopsy report before reading the reports from Dr. Arden and Dr. Andrew. So I did have an opinion. I don't think it's wrong to read other people's opinions also.
Now, let's talk about something else you learned in the course of forming your opinion in this case. You knew from the case materials that you were provided, and you knew from what you were asked to do in this case, that the defendant, Cara Rintala, claimed she left home at 3 p.m. on March 29th, 2010, correct?
Yes,
And that 3 p.m. time is referenced repeatedly throughout the materials that you reviewed, am I right?
yes, and it was posed to me when I was initially called about this case.
So, in forming your opinion, you realized the significance of whether Annamarie's time of death fell on one side of that line or the other side, correct?
Yes, that was the whole point of asking me for my opinion.
So you realized that if the time of death was before 3 p.m., that would mean the defendant was home when Annamarie was strangled to death, correct?
That would mean she was home when she died, yes, if she left at 3 o'clock.
Okay. And you realized that with respect to the time of death, 3 p.m. was a critical dividing line in this case, correct?
Yes,
Now, again, just like we were talking about a couple of minutes ago with the other experts' opinions that you could have put aside, did you ever ask the defense, like, don't tell me what time the defendant claims she left the house? I don't want to know that.
no, I was approached with, can you tell me whether she was dead after 3 o'clock or before 3 o'clock?
So right off the bat, when you're approached and you're asked to do some work in this case, that's a fact that you're given right up front.
Yes,
Now, you know from reading Dr. Andrews' prior testimony in this case that he was not told about that 3 p.m. dividing line when he formed his opinion, correct?
yes.
Now, Doctor, before we turn and discuss your own conclusions in this case, I'd like to just clarify something. You said you didn't bring a file with you today, correct?
I didn't bring it on the stand with me, correct?
Okay. You didn't write a report in this case, am I right?
Right.
Were you specifically asked not to write a report?
No,
When you were working for the chief medical examiner, you would routinely document your work and your autopsies in written reports, am I right?
yes, every case got a written, well, every autopsy case got a written report.
Now, as a private consultant, you have written reports in other cases, am I right?
I often don't.
Okay. Now, did you write anything in connection with this case?
We had email communications.
Okay. Did you contribute to the writing of a letter that summarized your testimony in this case about a month ago?
Yes,
Okay.
And did you specifically email some statements or some language to Attorney Scapicchio?
Yes, I helped write that, yes.
All right. And when you say you helped write that, let me approach you and show you a 2-page document. You just take a moment and look at it to yourself. Does that look familiar?
Yes,
Have you seen that before?
yes,
And is that the letter that you helped Attorney Scapicchio write to myself
yes,
earlier this month?
yes,
And you reviewed that for accuracy before it went out, correct?
yes.
Your Honor, may I mark this for identification only, please? Thank you.
This would be AA for ID.
Now, in addition to reviewing materials and forming an opinion in this case, did you also understand your task, your role in this case, the reason you were hired, was to assist with trial preparation?
Well, it wasn't clear when I was hired whether I would be involved in the trial.
Mm-hmm. So, like, for example, did you propose any questions that maybe should be asked of you or should be asked of other witnesses?
No.
Okay. Now, Doctor, I'd like to ask you about the degree of rigor mortis that was observed in Annamarie Rintala's body. Would you agree that her body was at least in well-developed rigor mortis, if not full rigor, when first responders found her that night?
Yes.
And you'd agree with me, and I believe it was your testimony earlier, that generally speaking, well-developed to full rigor mortis is typically seen 6 to 8 hours. You said that's the average of the bell curve, correct?
Well, yes.
Okay.
It's typical. It's
Mhm.
what the numbers are quoted, yes.
And you'd agree with me that rigor mortis first starts to set in, meaning it starts to first be observable, it manifests itself within a couple of hours after death, correct?
Within a couple hours, but it doesn't have to be a couple hours. It can
Sure.
be much quicker than that.
But typically.
Typically within a couple hours, yes, within
Yes.
a couple hours, someone would be showing signs of rigor, yes.
And those first signs of rigor would typically occur in the smaller muscles, for example, the jaw, maybe the eyelids or
Yes.
around the head area, and then gradually progresses into the larger muscle groups and sort of, I think the term in the literature is marches down the body. You've heard that phrase?
Yes.
Okay. So by the time it's getting into the larger muscle groups, farther away from the further extremities, that's when we're getting into the more well-developed and eventually full rigor, correct?
That's right.
Okay. Now, in the materials you reviewed, I believe you already said earlier, you saw descriptions of Anne's body moving as one unit when the police rotated her body, correct?
Yes.
You saw descriptions of there being absolutely no give in her fingers, her wrist, her elbow, and her shoulder, correct?
I had remember them saying that they couldn't bend them, that they
Okay.
were stiff.
You also saw descriptions of her hip and her thigh being completely stiff, am I right?
Being stiff, yes.
Okay. Doctor, I'd like to show you on the screen to your left there what was previously marked in this case as exhibit number 6. And I'm thinking you'll likely recognize this as one of the photos you reviewed in connection with your work in this case, correct?
Yes.
Okay. Now, are you aware of the fact that when the officers rotated, that is, they tilted up Annamarie's body about 45 degrees so that the defendant could wriggle her way out, are you aware that Anne's legs pretty much maintained that V shape when she was turned?
Yes, that would be consistent with the well-developed rigor
Okay.
that I already agreed to, yes.
And are you aware that the first responders, or at least a few of them, described that her arms were actually suspended off the ground and not touching the floor?
Yes, that's consistent.
Now, Doctor, let's talk about that 6 to 8 hour average that you talked about earlier this morning and just now reaffirmed in your testimony. You testified that that average, or the time frame within which rigor mortis can reach either its well-developed or full state, can be influenced by many factors, am I right?
That's right.
And you mentioned earlier that cold environment, or a cool or cold environment is a relevant factor, correct?
A cold environment can slow down rigor, and a hot environment can speed it up.
Mm-hmm. And that's something that's thoroughly documented and referenced in practically every forensic pathology textbook. Would you agree?
Yes.
Okay. Yet there was no mention of cold environment anywhere in the letter that you helped Attorney Scapiccio write. Am I correct?
Yes.
Okay. Now, from the materials that you reviewed in this case, do you recall the weather that night being rainy and 53 degrees?
I don't recall reading that.
Were you ever given a document entitled a death scene checklist prepared by Trooper McGarrian?
I don't know.
From the materials that you reviewed, would you agree that first responders found Annamarie lying on her back on a cement floor in the basement?
Correct.
And this was on a rainy 53-degree night in March in New England, correct?
If that 53 degrees, I'll take that as being true, yes.
Would you expect that cement floor to be either cold or at least cool to the touch?
Yes.
And from the materials you reviewed, you saw that Annamarie was lying, again, with her back against the cement floor, correct?
Yes.
As far as clothing, a sports bra on her upper half?
Yes.
So her skin, at least her upper body, minus the sports bra, would have been in direct contact with that cement floor.
Yes.
And on her lower half, just wearing sort of some scrubs or PJs, correct?
Yes.
And in your report, you didn't mention cold being a factor.
No.
And this morning, under questioning by Attorney Scapiccio, you did not testify that you factored in the coldness to your opinion, am I right?
Correct.
You also mentioned obesity, correct?
Attorney Scapiccio mentioned obesity, yes.
Oh, that's right. It was not in your, it's not your report, correct? The letter that I mentioned earlier, the AA that's been marked for identification, you wouldn't call that your report, would you?
No.
Okay. But this is a letter that you helped draft,
Yes.
summarizing your opinion.
Yes.
Okay. And just handing you AA, am I correct that nowhere in that letter do you make any reference to the cold environment in which Ann's body was found?
That's correct.
Okay. Nor anywhere in that letter do you mention obesity potentially being a factor in this case, correct?
Correct.
And did you understand this letter to be fair and accurate and balanced summary of what we could expect you to testify in this case?
Objection.
It's my letter, Judge.
Okay, but, no, based on the foundation that's been laid, overruled. Go ahead.
Do I think it's a fair representation of my testimony?
No, let me rephrase it. When you saw this letter and you knew what was going to be done with this letter, correct?
Yes.
Okay. Did you understand this letter to be a fair and accurate and complete summary of what your testimony was going to be at trial?
At the point that I wrote it, yes.
Okay.
Or at the point that I saw it, yes.
Okay. And when you saw that there was no mention of cold in here, you didn't insist that that be put in, did you?
No.
And when you saw that it contained no mention of obesity being a factor, you didn't insist that be put in, correct?
Correct.
Now, are you aware of research that indicates that obesity can actually slow down rigor?
Yes, the theory being that the oxygen is stored in the fat, and the fat can provide additional oxygen to the muscles to keep the rigor from forming as quickly.
Why didn't you mention that earlier?
When?
Under questioning by Attorney Scapiccio before the morning break.
Objection, Your Honor, she wasn't asked. This is a report I never asked her about.
Well, then that, if that's her answer, that's her answer, but I'll let the question stand.
What is the question?
So, Doctor, before the break this morning, you were asked about obesity and what effect it may have on rigor mortis, correct?
Yes.
Okay. And you told this jury that obesity can speed up rigor mortis because it can insulate the body and it can retain body temperature, correct?
Yes.
Okay. So, why didn't you also say there is research indicating that obesity can actually slow down rigor?
Morbid obesity.
Okay, so now it's morbid obesity.
Well, yes, she had 1 inch of subcutaneous adipose tissue, which isn't very much. BMI is based on weight. It's not based on percent body fat. And if you read the autopsy report, Dr. Richmond says that she had 1 inch of subcutaneous adipose tissue, which is 1 inch, which is not an unusual amount.
Okay. So now we know that obesity can go one way or the other with respect to speeding up or slowing down rigor, correct?
Yes.
Okay. Now, you also mentioned on direct testimony that when you're looking to either narrow down or determine a time of death range, you can also take into account outside or surrounding circumstances under which somebody died, correct?
Yes.
For example, if you had 2 eggs and toast and a slice of bacon on the plate, uneaten, and it was 3 o'clock in the afternoon, that could be a clue, correct?
Yes.
If a person had a pattern of always meeting the mail carrier at 11 a.m. sharp to pick up their mail, and on a particular day they didn't meet the mail carrier, that would be a clue, correct?
Yes.
Changes in behavior, changes in pattern of activity, correct?
Yes.
Okay. So, my question is, were you ever given any information in this case about the abrupt change in the pattern of activity on Ann's cell phone the day she died?
I saw that in testimony from other people reading the trial the previous testimony given by other people.
Okay. Have you ever seen the actual data itself?
No.
Okay.
I'd like to show you what's been marked as exhibits 148 through 150. Am I correct, Doctor, that you haven't seen these before?
Correct.
Okay. So is it fair to say all you know about Ann's cell phone activity on the day that she died is what you may have read about in prior testimony?
Correct.
Okay. Showing you what's been marked as letter V in this case. Have you ever seen this chart before?
No.
So are you aware then, from what you read in the materials, that the last
Outgoing call on Ann's cell phone was at 12:21 p.m.
Yes.
And do you remember what the next action or activity on Ann's phone was?
There was an unanswered call.
You believe there was an unanswered call after that?
I believe so.
About what time?
I think it was the number that comes to my head is like 150 or something, but I'm not sure.
Okay. And you recall that being an unanswered call?
I think that's what it said, an unanswered call.
And what was the next activity on the phone after that, if you recall?
I don't know, there was some call that was made from her phone to an aunt, and I don't remember the time of that.
So you don't know if that was before or after that unread text around 1:50?
Was that when the unread text was? I don't know.
Okay. Well, whatever you seem to think it was, around, I think you said about 1:50?
I don't recall the exact times. I know there was an unanswered text message, and there was an outgoing call that was not picked up, I think. to an aunt.
Now, when you read these transcripts, this was essentially other witnesses in prior proceedings describing cell phone activity, correct?
Yes.
And when you read those transcripts, did you call Attorney Scapiccio and say, I'd really like to see that data myself, because this may be important?
No, because the question I was asked of
Doctor,
Attorney...
I'm sorry to cut
If
you
you
off,
can
but
share
my
your
question is, you didn't ask to see it, correct?
Hold on, so, let me just hear the answer to your prior question.
Doctor, my prior question was, when you saw other people and read other people talking about the cell phone activity, did you call Attorney Scapiccio and ask to see that cell phone data yourself?
No, I did not.
Okay. Now, Doctor, with respect to some activity that you recall happening around 1:53 p.m., 1:53 p.m., if I were to suggest to you that that was actually a text message that came in that went unread, does that refresh your memory, or does that sound familiar? Or do you not recall it being a text or a phone call either way?
I don't recall which one it was.
Within the medical field, are you familiar with an abbreviation, CA, for cancer?
Yes.
Now, do you recall learning from those prior transcripts that throughout the morning of the day Ann died, she did 38 separate things with her cell phone between 8 a.m. and 12:21 p.m.?
I remember there being a lot of usage, yes.
Okay. And do you recall there being something being done on her phone on average about every 8 minutes?
I didn't qualify it to that. I just remembered there was a lot of activity on her phone.
When you assisted Attorney Scapiccio in writing this letter, which is AA for identification, am I correct, it contains no mention whatsoever of the change in the cell phone activity pattern on Ann's phone?
That was not the focus of my review of the materials. That's not what I was asked to do. I wasn't asked to tell her when she died. I was asked whether it was possible, based on the rigor, that she was alive after 3 o'clock or not. That's what my task was. I was not tasked with determining when she died. I was not tasked with determining who was responsible for her death. I was asked the simple question, based on the rigor, is it possible that she was alive after 3 o'clock or not?
So you don't have an opinion as to when Ann died?
I have an opinion that based on the rigor, you cannot say that she was dead after 3 o'clock, before 3 o'clock. That she was, based on the rigor, it's possible that she died after 3 o'clock.
And in reaching that opinion, you did not take into account at all the cell phone activity on Ann's phone, correct?
Correct. I was asked, based on the rigor, is it possible that she was killed after 3 o'clock?
Doctor, there's one additional area that I'd like to cover with you before I sit down, and that is your testimony about there being a physical altercation in this case.
Yes.
Now, you tell me if I'm wrong, but I understood your morning testimony to be that a violent physical struggle between Ann and her attacker was something that you took into account in suggesting that that 6 to 8 range may come down a bit.
Yes.
Is that a fair summary?
Yes.
And you said on direct that even though you think it may bring it down a little bit, you can't tell how much it would actually come down.
Right.
So 6 to 8, you can't say whether that shifts it to 5 to 7, 4 to 6, just an unknown, correct?
Well, it shifts it being the average.
Mm-hmm.
So, yes, I don't know where the average would go.
Okay.
I know it would be less than 6 to 8.
Now, in this letter that you helped Attorney Scapiccio write, you said evidence of a physical altercation and struggle prior to the victim's death could have sped up the rigor process, correct?
Correct.
Okay. You didn't say that it did speed it up. You said it could speed it up.
Yes.
Now, first of all, the research in this field speaks in terms of vigorous physical exertion prior to death, am I right?
Yes.
Not all struggles or altercations necessarily involve prolonged, vigorous exertion, do they?
No, they don't.
Now, in this case, what evidence or data can you point to that there was whatever struggle occurred, its duration?
Well, we know that the head wounds were there for some period of time before she died because of the bleeding around them.
Right.
The bleeding in the muscle was not huge, but it was present and visible easily. The petechial hemorrhages were widespread and significant in number. So, no, I can't tell you how long that struggle took place.
Okay.
No.
So what you just talked about, the head wounds came before the strangulation, which came before the death, correct?
Correct.
So we know the sort of the sequence of events as far as the injuries go, but the duration, the time frame in which all that happened, you can't say whether it was 30 seconds, 60 seconds, 2 minutes, 5 minutes, 10 minutes, can you?
No.
There's no data or evidence in the materials that you reviewed to say one way or the other, fair to say?
One way or the other, what?
How long the struggle was?
Well, that's not one way or the other.
Okay,
There's
maybe
no
I
way.
phrased
There's
my
no.
question wrong.
There's
or
no.
poorly.
There's nothing to say exactly how long that struggle was. Right.
Similarly, is there any evidence or data indicating whether Annamarie actively fought off her assailant or was just simply a passive recipient on the receiving end of this assault?
Well, she tried. She wasn't passive because there's evidence that she tried to remove whatever was around her neck.
Right, and you're citing the marks on her neck for that proposition, correct?
Yes.
In this letter, you state that those marks are consistent with her having scratched herself while trying to release the pressure around her neck, correct?
Yes.
So what evidence or data in the materials that you were provided can you point to that those marks actually came from Annamarie's fingernails as opposed to her assailant's?
My recollection was that the nail clippings did not reveal anyone else's DNA under her fingernails.
All right, and it's common in your experience as a medical examiner, you can either scrape fingernails or clip fingernails at an autopsy, correct?
Mm-hmm.
And in this case, Annamarie's own DNA was found underneath her nails, correct?
Yes.
Okay. So if her attacker were scratching Ann's neck, her attacker would have Ann's DNA under her nails, correct?
Objection as to her.
Her being Ann.
Okay, so is it, I'm not sure what the basis.
I can rephrase the question, Your Honor, I
Thank
think, to fix it. So, Doctor, my question is, if Ann's attacker were scratching Ann's neck,
Yes.
that attacker would have Ann's DNA under their nails, am I right? Most likely?
Most likely, yes.
Okay. And if Ann is scratching at her own neck, Ann's getting her own DNA under her nails, but her DNA would already be under her nails, wouldn't it?
Yes.
Okay, basically everybody walking around with fingernails, we've got our own DNA under and on and in between our nails, correct?
Yes, that's why you look for someone else's DNA under the nails if they had fought off someone by scratching them.
Right. So you just said a moment ago that the fact that Ann only had her own DNA under her nails suggests she scratched her own neck?
Yes. In an attempt to remove what was around her neck, which means she wasn't passive when someone was trying to strangle her. She was attempting to remove it,
Okay.
and in the process scratched herself.
And what evidence can you point to that those marks didn't come from her attacker?
They are just commonly seen. I said it was consistent with her doing it
Consistent.
because it's common
Possible?
for that to happen.
When you say consistent, you mean possible?
It's more than possible. It's a recognized sign of someone trying to pry someone's hands or something else off of their neck, that they injure themselves in that process.
Now, did you also take into account the disarray in the basement in concluding that there may have been a struggle in this case?
I wasn't focusing on the disarray in the basement. The body has enough injuries on it, the disarray in the basement, and other people were down there, and I don't know how all that happened. My basement's not that neat.
Right.
So
Now, I'd like to discuss a few other injuries that Ann had that may have reduced her ability to fend off her attacker. Well, let me ask you this. Would you agree that some or all of the injuries that Ann sustained prior to her death could have reduced her ability to fend off her attacker?
Some or all of them reduced her ability.
Yes.
I suppose they could have, but there's no evidence that that happened.
Well, let me show you what's been marked as exhibits. Let's start with 22. I assume you're familiar with this photo?
Yes,
And that would be a large contusion to the top of Ann's head, correct?
yes,
Exhibit 23. Would you agree that's a rather deep penetrating wound to the left side of her head?
it's a laceration.
And exhibit 24. Closer up view.
Yes,
Significant laceration, wouldn't you say?
yes,
And that would be likely to induce pain on
Yes.
Ann's part?
yes,
Exhibit 25 and Exhibit 26. A significant, is it a V-shaped, crescent-shaped laceration to her head?
yes,
And that penetrates down to the skull, correct?
yes,
Fair to say this would also induce considerable pain.
yes, that would be painful.
Exhibit 27. See on the lower left-hand corner there, a shaved portion of Ann's head?
Yes,
And that's another laceration to her head, correct?
yes,
Exhibit 28. Closer up view of that wound.
yes,
And Exhibit 29. This is an opened view of that same wound, correct?
yes.
Another deep penetrating injury?
It's a laceration.
Okay. And would you characterize any of these as superficial?
Well, that's a superficial as opposed to they don't go inside the body. They're on the superficial aspect of the body. They're on the skin, covering the body. They're not wounds that involve the skull or the brain. They're superficial. They're not insignificant.
Would you agree that this injury would also have caused a considerable amount of pain on Ann's part?
Yes, that would be painful.
Okay. You also noticed that there were multiple bruises and abrasions about her body, correct?
Correct.
And you'd agree with me that the bleeding and the swelling associated with those head injuries suggests she was alive prior to being strangled to death, am I right?
That's correct.
Right. And speaking of the strangulation, Ann could have been strangled from behind, fair to say?
Yes,
You've seen cases where individuals are strangled from behind, from in front, standing up,
Yes.
lying down, correct?
yes,
Have you seen cases where people are strangled by the attacker's forearm or some other part of their body?
yes,
Would you agree that Ann was lying face down for some period of time after she died?
yes,
And that's known from the fact that there was some lividity, some pooling of the blood on her front side before she was turned, correct?
well, more consistent, the more telling fact that she was lying on her front for some period of time was that when she was flipped over onto her back, her hands weren't on the floor.
They were
So-
like an anti-gravity state, correct?
Yes, I mean,
Right.
the rigor was more indicative than the liver.
So if at the moment she was being strangled, let's assume she was being strangled from behind, would she have remained face down once the life went out of her?
If she wasn't moved,
Now, speaking of the life going out of her, am I correct that a person can lose consciousness in as little as 10 seconds of sufficient force being applied to their neck?
yes,
And then for the following, is it fair to say that 3 to 4 minutes of sustained pressure is required to strangle someone to death?
that's the literature, yes,
Okay. So after as little as 10 seconds of being strangled, Ann would likely have been unconscious.
she could have been unconscious, not necessarily.
And then for the next 3.5 to 4 minutes of sustained pressure around her neck, the blood flow, the oxygen flow to her brain is plummeting, correct?
Yes, but you're assuming there are a lot of different ways this can happen.
Sure.
So the pressure has to be applied without intermittence, right? So like if you're struggling against someone who's trying to strangle you and the pressure is released, that initial period, you're not unconscious necessarily that quickly, because you might be successful somewhat in removing the pressure enough to keep yourself conscious. So yes, in a straightforward, scenario where there's no interruption and there's no intermittency of the occlusion of the veins, yes, that's correct. But it can be quite long that someone is in the process of being strangled if they are fighting and relieving that pressure intermittently. So it's not, all these things can happen, but it's not necessarily that when someone is strangled, they're unconscious after this many seconds and then they're dead after this many minutes.
And I think I said or meant to say 3 to 4 minutes of sustained pressure.
Yes.
And ultimately that causes a decrease of oxygen to the brain.
Yes.
And ultimately it's that depletion of oxygen to the brain that resulted in Ann's death. Am I right?
Correct.
And you don't disagree with Dr. Richmond's conclusion that Annamarie Rintala's cause of death was manual strangulation, do you?
No.
And you don't disagree that multiple blunt force trauma injuries to her body, including her head, were contributing factors to her death, do you?
Well, they're contributing factor. There's only one place to put other things on a death certificate, and it happens to be called contributing factors. But they're there, and they're significant. Whether they contributed to her asphyxia, they may or may not have, but they have to be listed because they're significant injuries.
Sure.
But I wouldn't necessarily say they contributed to her asphyxia.
Right, meaning they didn't, those head wounds in and of themselves didn't kill Annamarie Rintala.
And they may have had no effect on her ability to defend herself. I don't know.
You don't know because they could have.
They could have, or they may not have.
Anything's possible?
Well, anything, but those two things are possible, yes.
Thank you, Doctor.
I have no further questions.
All right, you step down, thank you.
Thank you.
Can we part sign off?
Jennifer, could you grab AA?
Members of the jury, I was reminded there's something that I need to attend to quickly, so we're going to take a second mid-morning break. This one is going to be for just 15 minutes, and then we will proceed from there till the lunch break. So if you can be back in 15 minutes.
Court all rise, please.
Thank you, Your Honor.
Thank you.
can we be seen inside just briefly? Thank you.
Okay, so,
You want her to stand up?
sure, I just need her to be, she can actually be seated as long as I can see her and she's near a microphone, so,
So it's,
yes.
you have to stand up. Okay.
Cara, if I could ask you to please raise your right hand. Do you swear you'll make true answers to such questions as may be asked you by the court in the manner now pending before this court? So help you God, or do you so affirm?
I do, thank you.
Okay, Ms. Rintala, I just need to ask you a few questions concerning whether you wish to testify. Can you state your name?
Cara Rintala,
And how old are you?
57.
Okay.
No, 56.
Okay. How far did you go in school?
Bachelor's degree.
All right. And I understand that you were an EMT for a number of years and a firefighter, is that correct?
Correct.
And do you suffer from any mental illness or disorder?
No.
And have you consumed any drugs or alcohol within the last 48 hours?
No.
Okay. Now, I've been informed that you may wish to waive your right to testify, and I just need to ask you some questions about that so that I can be sure that that waiver is knowing and voluntary, that you understand that right. So, do you understand that you have a right to testify?
Yes.
And you also have a right not to testify, and if you don't testify, if you ask me, I will instruct the jury that they can't hold that fact against you or consider it anyway. I'll give a lengthier instruction, but I will give an instruction on that. Do you understand that?
Yes.
And do you understand? And have you had enough time to discuss this with your attorney?
Yes.
And so you've gone over with Attorney Scapiccio and your other attorneys the pros and cons of waiving that right to testify.
Yes.
And do you understand that it's your right? It's not a decision for your attorneys to make. That even if they advise you against testifying, you can disagree with them and assert that right. Do you understand?
Yes.
Okay. And do you feel it's in your best interest to waive that right and not testify?
Yes.
All right. So I find that Ms. Rintala is competent to make this decision and that she understands the nature of the right that she's waiving. Well, let me ask you, has anyone forced you or made you any promises to cause you to waive that right?
No.
Okay. And I find that her waiver is knowing and voluntary.
Thank you.
Okay, so before we bring her back out, I guess this does change the schedule a bit. It puts us ahead of schedule considerably. The jury, I'm sure, will be happy to hear about that. We're obviously not ready to go into closing arguments and charge, but I just want to get a sense as to how much time or when you think you would be ready for closing arguments. I'm thinking tomorrow, but
And I will leave it up to the court judge. I could close this afternoon if you needed us to.
okay.
But I don't want to leave the Commonwealth in a position where they haven't had adequate opportunity to prepare their closing.
Okay. So my inclination would be, because we are wrapping up earlier than I expected,
And
I would be inclined to release the jurors for the day, and then we can spend some time this afternoon discussing the charge.
Yes.
And then once we're finished with that, we'll end our day, and the parties can spend that additional time preparing for closing arguments, which we would do first thing in the morning. Does that sound reasonable?
that's fine, Your Honor, with the defense.
Yes, we agree.
Okay. So we'll bring in the jury. You can formally rest, and I will explain the schedule.
Thank you, Your Honor.
Court all rise, please.
Jury entering. May I, Your Honor?
You may.
Cara Rintala rests.
Okay. Members of the jury, I told you that we would be going to the lunch break, but I think that there's a fair amount that the attorneys and I need to do, at least for my end, before we're ready for the next stage of this trial, which will be the closing arguments of counsel and my final instructions to you on the law. And so that we are ready to do that, or so as to give us enough time to prepare, and so that you're not waiting around while we do that. I'm going to release you for the day and ask that you be back tomorrow at 9 o'clock. And again, at that point, you should expect to hear closing arguments and charge. Once again, please do not discuss this case with anyone, including each other. Please refrain from any form of outside research or investigation concerning this case. And please avoid contact with any of the participants in this case, and avoid any and all media accounts of this case as well. And I will see you tomorrow morning at 9 o'clock.
Please rise and pass the chairs, please. You may be seated.
Okay, so perhaps it makes sense simply to break now. Come back. I have a short matter at 2, so that should take about 15 minutes. Perhaps we can resume or reconvene at, say, 2:15 or thereabouts, and at least begin our discussion of what the charge should be. And there's probably another motion.
That's correct.
Okay.
So
Did
I
you-
do that at 2:15 as well. Doesn't have to be now. I just wanted to let the court know we would be.
Right, right.
We want an opportunity to at least present the required finding of closing all evidence.
Of course. But assuming I don't allow that motion, then we would proceed, or if I don't allow that motion, we would proceed from there to discuss the charge.
That's correct.
Is that agreeable? Okay.
In fact, I said I would get the jury instructions on Monday. We didn't finish them until late last night, so we do have a set of jury instructions. we can give you.
Okay. I'll take those now. Thank you.
If you don't have any problems.
Thank you. Okay, so we'll see you at 2:15.
Thank you.
Well, all right.
You really have a long lunch.
Yeah.
Look at that.
I know, it's like it's about you then.
Oh, it's special.
You don't have to order. Go there.
I'm glad to do that. Sure.
Yeah, she's gonna do that. Why don't you text him? He doesn't have to be here.
Yeah, that would actually be.
Why don't you text him and tell him, get back on a plane? Or come, go straight to the hotel if that's what he wants
If
to
you
do.
have it, right.
Oh, you decided not to use it.
Yeah. We don't need to waste that trip unnecessarily.
I got it. I got the wife's, some sort.
Yeah, no, I got it.
202, I think
Wife.
it's that
Can I get
202
that?
number.
0CR12.
Good afternoon. Okay, so let's start with defendant. Is there a motion?
Yes, Your Honor. We filed, I think I gave it to Clerk Jaganowski, motions. Oh, sorry. Sorry. Motion for required finding of not guilty at close of all the evidence. Yes, we would renew.
don't have it.
No. Sorry, my mistake. That's an oral motion. We're essentially supplementing the written motion, which we filed at the close of the Commonwealth's case. And we are making an oral motion under 25B for a required finding at the close of all the evidence. And we would waive argument at this point.
Okay. Well, again, under the Lattimore standard, that motion is denied.
Without our objection.
Okay. And so, as to the instructions.
Yes. Would you like me to start?
Well, perhaps, but I believe there may be some agreements, or at least an agreement.
Yes, Your Honor, I believe the parties have agreed that we are jointly asking the court to instruct on the lesser included offense of voluntary manslaughter with heated passion upon reasonable provocation and sudden combat being the mitigating circumstances.
Yes, Your Honor. Just to be clear, the Commonwealth has submitted a proposed instruction, and we would object to the language in that instruction. We agree with what Mr. Gagnon just said, but we were asking for the model instruction to the extent that it covers voluntary manslaughter under those two theories.
Okay. So, just so you both know, I will likely be hewing very closely to the model instructions, the SJC's model homicide instructions. I will hear and review the party's suggestions otherwise, but at least my thinking at this point is that I will likely just adopt that language. So we can go, I don't know what order you want to pursue this. I would suggest that perhaps we start with what the parties think they need decided for the purposes of their closing arguments. So we just kind of prioritize it in that way. Not that I won't try and get a rough draft to you before the end of today, but just so that there's no question about whether you should include an argument or language in your closing arguments. So, does that make sense to start there?
Yes.
I'll start with, you're standing up, so we'll start with you.
Thank you, Your Honor. So what we would actually start with is page 15. This is our proposed instruction. It's not a model instruction, but it's based loosely on the model instruction. The Bowden, inadequate police investigation, or the Bowden claim. And so we've crafted our own language starting at page 15. So obviously we have made the failure to investigate a centerpiece of our defense, and we would ask for the Bowden instruction, in some sort at least, and we would note as a preliminary matter that Judge Rupp gave the Bowden instruction at least in prior proceedings. So that's the place to start. Yeah. Right, and then the thing that is most important to us is actually something that we crafted ourselves. The very final paragraph, we feel that we assume the court is going to give at various points an instruction that I instruct you, I instruct you jurors, you may not, that speculation and guesswork may not be a part of your deliberations, sort of standard language. We feel that that language, in the context of a Bowden defense, especially this Bowden defense, in this case, where it's so important, where we're focusing so much on what the police didn't do, it's crucial that you contrast our argument with that prohibition on guesswork and speculation. So specifically the language we have here, I have instructed you elsewhere that your verdict may not be based on speculation. However, I instruct you that if you determine there were relevant omissions in the police investigation that bear upon your verdict, that would not be improper speculation. And then if we cite a relevant case, Commonwealth v. Salentino. And I would also note a couple things. First of all, it has been held by the appeals court that the Bowden instruction is optional. In other words, it's up to the court, but it's discretionary. But it's preferable. That's 29 Mass Appeals Court 537 at 540. Quote, it is preferable to instruct jurors that the evidence of omission could create reasonable doubt. So we would request that instruction, and we would request the language to distinguish that from speculation.
Okay. Do you want to just go topic by topic?
That makes sense to us. Sure.
Your Honor, we used the time we had during the lunch break to file requests that we were making. We didn't have a chance to adequately research or write up an opposition to what had been handed to us this morning. However, I will inform the court, and perhaps we could supplement this in the morning with a memo. We have continuously opposed a Bowden instruction being given in this case in each of the previous trials. It is certainly fair game for counsel to argue. They have argued in the past. We know they'll argue it tomorrow. But in our view, when the court gives a Bowden instruction in referencing that the jury has heard evidence of X, Y, or Z, we feel as though that's sort of tipping the scale and telling them that there is evidence in this case of omissions or oversights or inadequate investigation by police. That we feel is for the jury to decide. If the court is inclined to give a Bowden instruction, I think it's critical that we hew very closely to the standard Bowden instruction, that we not go off course here. And I find the defense's proposal about speculation being confusing. It seems to suggest to the jury that they cannot speculate, yet in some circumstances perhaps they can. My understanding of Bowden is that if certain steps weren't taken by the police that you would ordinarily expect the police to do, the jury can factor that in, but they are not to speculate as to why the police didn't do something or what they might have uncovered if they had done that. So this instruction, I find, is inviting speculation. And if there's one thing we need to be crystal clear on with this jury throughout, is that there can be and should be no speculation on either side for any reason.
Could I just have one short last word on that, Your Honor?
Sure.
Your Honor has made reference to Commonwealth v. Pena already, I think, today. We think that Commonwealth v. Pena speaks to this, and specifically that the court held that it's permissible for the jury to draw an adverse inference against the Commonwealth for not calling witnesses. So, at least to that extent, we think it is appropriate to permit the jury to infer things from the failure to investigate.
I guess I didn't read the holding in Pena to say that necessarily, but my thought at this point would be to give a Bowden instruction, but to give kind of the standard instruction. I also think it makes sense to repeat some of the limiting instructions I gave when the testimony came in, and I would specifically remind the jury about the instructions I gave with respect to Mr. Olasak and Ms. Daniele, the testimony about them in the way that the jury could consider it, as well as the testimony, I think, that related to some of the videos where the witness was testifying to what was happening in the video, and I instructed the jury that what was happening in the video was completely up to them, but they could still consider what this witness thought was happening, so to speak, as it related to his state of mind and what he did in terms of the investigation. So if I gave an instruction at the time, I will likely repeat that instruction. So that would be kind of part and parcel of the Bowden instruction. The only thing I would say, the only thing I'm going to look at here is that the standard instruction, I think, puts maybe more emphasis on forensic testing than makes sense here, just so the jury understands that what this instruction is really about. Now, I think the Bowden defense here was broad, and it touched upon a number of aspects of the investigation, which is why I permitted a fairly broad response. But I think that the focus is really the failure, according to the defendant, of the police to pursue or pursue more aggressively two third-party culprits in particular. And so I may change the language a bit just so that it seems to track with that, but otherwise it would be consistent with the standard instruction.
That I understand, Your Honor. Is it possible to give us, I'm just sort of trying to figure out the sequence, for us to see your proposed final instruction so that we can, before you give them, so that we can articulate?
I'm going to do my best to get you some sort of draft before I leave here today.
Right.
But I didn't expect that that we would be this far along. I'm not complaining. I just
Right. No, I understand.
I thought I would have this evening to work on these instructions. So I still plan on working on these instructions this evening. So what you get today is by no means necessarily what I plan on giving tomorrow. We will take a break after the closing arguments, and maybe a lengthy break. I also will do my best to get you a revised copy sort of first thing tomorrow morning, so you have a little bit of time to kind of look through, and then you have your own copy for our post-closing argument discussion.
Okay.
And again, I just want to make sure that everyone understands what topics are sort of available to them to argue about. So, and as you know, you can argue Bowden whether I give the instruction.
But I'm hearing you say that you expect to give a Bowden instruction.
I'm going to give a Bowden instruction.
Right.
Again, I don't know that it's going to look like the one that you propose. It's going to look more like the standard instruction, although it may have less emphasis on forensic testing, just so the jury understands.
Right. And just
so as not to confuse the jury, just given the nature of the defense here, and also a reminder concerning the sort of the limited purpose for which a lot of this evidence was introduced.
Understood, Your Honor.
Before we leave Bowden, Your Honor, your last comment there just reminded me that on the topic of Bowden, obviously a lot of evidence, a lot of testimony came in about what the police learned about Mark Oleksak and about Carla Danieli. So my understanding tomorrow is that in closing arguments, both sides should tailor their arguments accordingly and, for example, not stand up in front of the jury and state as though it was a fact that Mark Oleksak was owed money by the victim, or that he in fact was sleeping in her sleeping bag after her death, because that would be arguing those facts as true. So, I think there's a time-honored tradition that counsel tries not to interrupt each other during their closing arguments. I'd certainly like to keep that tradition going tomorrow, but if I hear this evidence that came in, not for its truth, being argued for its truth, I think it's incumbent on all parties to have a clear understanding of where the boundaries are tomorrow. Similarly, this dovetails with the motion that Attorney Sewell argued this morning, this issue of whether the Commonwealth should have called or was obligated to call certain witnesses. I think that would also be improper, that is not Bowdoin evidence. Bowdoin has to do with the investigation, not with trial strategies. It is a fact in this case that both parties had equal access to witnesses. Mark Olczak was in the hallway all morning this morning, and we were being told that he was going to be testifying this afternoon. The defense chose not to call him. So to the extent the defense wishes to argue somehow that the Commonwealth had a burden to produce these witnesses and they failed to do that, I also think that would be an improper argument. That's the same argument that was made in opening statement. So I think it's important that we all be on the same page about that.
Okay, so let me give you my thoughts on that, and then Attorney Scapicio, if you want to,
Sure.
You're free to address the same issue. So this is a Bowdoin defense. It's not a third-party defense, and although third-party culprits are sort of at the heart of the Bowdoin defense, it's true. The argument is, again, what information was brought to the attention of the police and what they did or didn't do with that.
Absolutely, understood.
Okay. As to the failure to call certain witnesses, I don't think it relates to Bowdoin because it's not part of the investigation. And there hasn't been, in my view, a foundation laid for a missing witness argument and instruction. But the Commonwealth has the burden of proof, and the defense is free to argue that it didn't produce certain evidence or call certain witnesses. And the Commonwealth is free to address the reasons for doing that, or the import or lack of import. So again, so long as you are not asking the jury to infer anything about what the witnesses would have said that were not called, I will.
The only, I didn't mean to cut you off.
Sure. Oh, no, go ahead.
The only issue, I understand everything you're saying. I've argued Bowdoin on a number of occasions. I understand how to argue it. I understand the court's parameters in terms of what is and isn't in substantively. But the issue of drawing an adverse inference, I think under Commonwealth versus Pena, the fact that the witness wasn't called by the Commonwealth in this case could result in an inference against the Commonwealth if it would have been normal and natural for them to call that witness. I think that's what Commonwealth versus Pena says.
Well, Pena really goes to, I mean, there's language in Pena that's really taken from other cases.
Yes.
Pena is really more about the judge properly striking improper missing witness type arguments or a missing witness argument. So I don't know what adverse inference, again, so long as you are not asking them to infer anything about the testimony of those witnesses who did not testify, specifically that somehow that testimony would have been adverse to the Commonwealth, which is why they didn't call them, or if the testimony was beneficial, you would have expected. But this is a criminal case. The Commonwealth has the burden. I don't know that one would expect the Commonwealth to call these potential third-party culprits as part of its case, but I'm sure that the jury is wondering why they haven't heard from Jamie McGarrion, who's been described as the lead investigator. And so I think it's permissible to simply make that point, but I wouldn't permit you to go beyond that in terms of, again, the substance of what that witness would have said, or what evidence that witness would have produced had he been called, because I think that goes to, or that is a missing witness type argument, and I do not find that foundation has been
And we're not asking for
Okay.
missing witness instruction, Judge. I think you're right. I think it goes to the Commonwealth's burden.
It's, okay, so
Okay.
that I think is permissible to argue.
Thank you. There's one additional thing before I forget, Judge, and that is I've been asking for the last 4 years, so I'm going to ask again. I can tell you right in front, I've never gotten my request granted, but I think the only way to change the law is to push it. So we are requesting an opportunity for rebuttal. I know what the law says, I know what the SJC says, but there's at least one recent case where there's some indication that rebuttal would be appropriate. And we want to make sure that we preserve the right to at least ask for a rebuttal argument in this case.
Okay, so you made the request. I'm going to deny that request.
Sorry, Judge. Sorry.
That's okay. So back to the model instructions. I think I propose, for, at least from our side, we've given you a lot here. This is my suggestion for efficiency. There's basically 2 sections. The first section is listing model instructions, and basically we're saying we request these model instructions. And there's a second section that has other instructions, which included the Bowden instruction, which is the most important one to us already, so we've covered that. But so I'll just have 2 brief comments on each section. So on the model instructions, the only thing I would actually highlight is so part 1D3, prior bad acts. So this obviously is evidence of primarily of the marital discord. So we would ask that you simply give the model instruction on prior bad acts generally, and we would object to any mention of specific alleged bad acts in the model in the instruction you give. Simply that, just simply instructing that they've heard evidence of prior alleged bad acts, and here are the reasons you can consider. You can't consider it for the truth of the matter asserted, or that to conclude that Ms. Rintala is a bad person. Character evidence, but here are the reasons you can consider that sort of evidence. Essentially, hewing to the model instruction without getting into the specific alleged prior bad acts.
Okay, so what I had in mind was this. I would say that they have heard evidence about restraining orders, divorce filings, arguments between the defendant and the alleged victim and the defendant, and that the defendant was arrested and charged with assault and battery, a charge that was later dismissed. You may not take any of that evidence or this evidence as a substitute for proof that the defendant committed the crime charged, nor may you consider any of that evidence as proof that the defendant has a criminal personality or bad character. But you may consider this evidence solely on the limited issues of motive, state of mind, and intent as to whether there was a hostile relationship between the defendant and the alleged victim. You may not consider this evidence for any other purpose. So I don't use the term bad acts because I don't. The closest thing to a bad act here is an assault and battery charge that was dismissed. So I think it makes sense to let them know what evidence I'm referring to, just as I did when that evidence was introduced, so that they don't wonder if they missed something. But I simply take out the acts or the bad acts or even reference to acts, because these aren't necessarily even acts of the defendant having a restraining order issued against you. Is not a bad act. It's something that happens to you, not something that you do. So that's my thinking.
So I largely agree with that, Your Honor. I just have 2 sort of short amendments. I think you're right to, instead of prior bad acts, to focus on specific things. I noted that you, on the assault and battery side, which was later dismissed, I, of course, agree with that. But in going through the restraining orders and the divorce proceedings, both of those were also voluntarily withdrawn. So I would ask that all of those, I think those are the 3 categories, restraining orders that were voluntarily withdrawn, divorce proceedings that were voluntarily dismissed, and an assault and battery charge that was ultimately dismissed. I think that's actually what the record shows, and that's how we'd ask to have those characterized.
All right. I mean, that may be so, and you can make that argument.
Okay.
But I think they're more or less categories of things. That additional language, I think, on the assault and battery charge is important, just because of the nature of that alleged prior bad act. Again, it's not it's not really even a prior bad act, as it's just something that happened that the jury could consider as sort of motive or just as evidence of marital discord and a hostile relationship. So I understand what you're saying, but I think I'm going to stick with this language. And again, you're free to point out in your closing argument how those other things were turned out.
Yes, Your Honor. No, just note our objection.
Okay.
And then, oh, sorry.
Go ahead.
The other broad category, as I mentioned, is part 2, where we essentially have some customized instructions that cover things that are also otherwise covered by the model instructions. And we would, I think, I would actually waive argument on all of these things other than the Bowden instruction, which we've already covered, and it also includes some objections to aspects of model instructions, and we would rest on the papers on those things. You'll see that those are quite clearly things that are take different approaches than the model instructions, and I understand you're saying, look, I'm mostly going to go with the model instructions. To the extent we just ask you to look at these, take them under advisement, and we preserve our objection to the extent that the model instructions that you give are inconsistent with these requests.
Okay, thank you.
Thank you.
I did have a question about your request for an alibi instruction.
Yeah.
And I ask only because it's an odd sort of case for an alibi instruction, because it seems to me it's not so much that the defense, that is, isn't so much that she wasn't at home when the murder occurred, it's that the murder occurred when she wasn't home. If you understand.
I understand.
My meaning. So, is anyone planning on using the term alibi?
We've used it in the past, but
Okay.
if that's going to be...
No, I'm not opposed to giving the instruction. I just, again, the way that the model instruction reads, to me, it doesn't quite fit with what this case is about.
Right, I would agree. In most cases, when the crime happened...
It's sort of a fixed point.
And the defendant tries to show that he or she was in another
Right,
place.
the question is whether you're convinced by that evidence that the defendant wasn't there at that point that everybody seems to agree on. So this is sort of the opposite of that. Doesn't seem to be that much dispute about when the defendant was out of the house. The real issue is when the murder occurred.
So we would broadly agree with all of that, and we're not we're not thrilled with using the word alibi at all. It sounds like the settlement here, or the agreement here, is one we would be happy to accept, which is if the Commonwealth is saying they will not use the term alibi, then we would agree that you shouldn't give an alibi instruction.
Okay. And I'm not going to require that of you, but it doesn't, again, the word alibi doesn't really seem to make a lot of sense here. Or, I mean, I know you've used it in the past, but it's not an alibi defense in the way that we normally view that.
We've argued in the past, and frankly, I think we are inclined to argue again that Cara Rintala took several steps that afternoon to actively put herself in other places, doing other things, making transactions, being on video. So she was attempting to create, I think the term we used in prior trials was a digital alibi. So that's our argument, that we are urging the jury to infer that she was consciously doing something to create a false alibi. But again, I think we're...
But it's not, right. So that's the argument so the Commonwealth is using that argument, but it's not to rebut a defensive alibi.
I would say it's more like it's a shade on the consciousness of guilt argument, that she's doing things to cover her tracks, essentially. But alibi, where we don't know the precise time of death and where we don't know, frankly, for 2 hours exactly where she was after 3 p.m., I think alibi would be confusing to the jury.
Okay.
Yeah, so I mean, I think you understand, well, I don't know our position is that, just as in the past, if the Commonwealth uses the term fake alibi, then we feel, unfortunately, that an alibi instruction, especially because this term alibi, as the model instruction suggests, has come to have a sinister connotation. And so the problem is, of course, if they're going to be calling it a fake alibi, suggesting this sinister connotation, then we feel the best option is to have the alibi instruction, most of all because it says, don't think that the term alibi is something inherently nefarious. So that's where we are. If they're not going to use alibi, then we don't need the instruction.
Okay. So the alibi instruction, the model instruction, I think has a couple different parts. So there is one part that just talks about the term. An alibi simply means that the defendant isn't at the location of the crime. It's just evidence of that.
Right, the second paragraph of model instruction, I assume you're talking about.
So I'm wondering whether the first three paragraphs would make more sense. The last paragraph seems to focus more on a traditional alibi defense.
When you say the last paragraph, I think you mean, please give this issue, is that what you're talking about? Or are you talking about?
Oh, no. So.
In this case, you have heard?
In this case, you have heard.
Right, okay. I think it's, yeah, if we just get the first, no, sorry, hold on one second, Your Honor. Yeah, I mean, I guess we would ask for the fourth paragraph as well. Our basic thinking is, you know, she obviously, there's the statement, I mean, our defense is very clear that, and the evidence is very clear that she says she was out shopping and doing other things at the time that we believe the killing occurred. So she couldn't have been present when the killing occurred, and so it's that very classic idea of alibi. And the Commonwealth couldn't effectively, although it's perhaps an odd structure, the Commonwealth couldn't prove that she was home at the time the killing occurred. If the jury accepted the killing occurred at 5 p.m., then she was clearly not home at that time. That's the alibi.
Well, I suppose in that sense it is an alibi defense. So look, I will give the model instruction, but if the Commonwealth can think of a better term to use, then maybe I can omit that portion entirely.
Right. That's our position. That if, to be clear, if the Commonwealth, and obviously the sequence will be the Commonwealth will argue and you'll give the instruction. If the Commonwealth avoids that language, we would withdraw the request, and because we're not crazy about mentioning it and putting it in those terms.
Okay. What about, so the Commonwealth described its argument in terms of consciousness of guilt. Is either side asking for an instruction on that?
We are not.
Okay. There's an agreement.
Okay.
So my last point, actually, no, I already reached my last point.
Okay.
You raised the alibi and that was it. Thank you.
Okay. So, as far as the Commonwealth's requests, I've already covered the limited use of Bowden evidence. I will likely re-instruct the jury on whatever I instructed them during the course of the trial, which would include the instruction about prior proceedings, and I would just repeat the same instruction that I gave. I think I gave some, because I gave an instruction on voluntariness as to the video, I will basically be giving that same instruction. And that includes an instruction that concerns the redactions to that video, but I can also include under sort of the more general heading of exhibits an instruction. So there are other exhibits that have been redacted.
Yes, there is some of the restraining order. I'm not sure the documents themselves, but the restraining order hearing has redactions. There is a contact list from a victim's cell phone, which is subject to redaction this evening by the defense. So we do have it in video, audio, and documentary format. Redactions, that is.
Do you know the exhibit number for the defendant's statement?
I believe it is 30. Exhibit 63, by our count, is a thumb drive that has both videotape statements on it.
Okay. And then I will repeat the instruction I gave about the subtitles. Can you tell me what exhibit?
Exhibit 41, which is a 911 call. Exhibit 47, which is the restraining order hearing. Exhibit 54 is a DVD with 5 voice messages on it. There are a few, I wouldn't call them subtitles, but there are some headings on the surveillance videos. For example, entering mall, exiting mall, but that's not really a subtitle because it's not representing what the audio is, so I don't think that instruction would apply to those.
It's not from a transcript that you obtained?
Correct.
Okay. All right. If I can, I'd like to include the exhibit numbers. And so I can give an instruction generally about redactions, and I don't know that I need to list every single thing, but if you would like me to, I just need kind of a list of those exhibit numbers.
Certainly.
So that leaves a couple of additional requests, but before I get to that, let me just quickly go through just the topics that I have so far, in case, as I go through it, you think that there's something that we haven't discussed that we need to, at least before the closing arguments. And if when I say model instructions, Superior Court doesn't have, we're working on our own set of model instructions. The SJC model instructions on homicide, their homicide instructions rather, are obviously model instructions. And again, I will likely follow the wording of those instructions. There are a few things that we have agreed upon, the Superior Court, that is, as sort of a model instruction. But a lot of this language is taken either from the MCLE Superior Court instructions or the District Court model instructions. But when I use that term, what I mean is that this is language that you've likely seen before, that this is not my own language. So I will instruct on presumption of innocence, burden of proof. That language, again, is not going to get creative with the language for burden of proof. I'll talk about the role of counsel, my role of the jury. Again, I think language that will sound very familiar to you. What is evidence, what's not evidence. I will describe the difference between direct and circumstantial evidence, and in that section I will get into what an inference is and what happens when two things are presented that seem equally as likely. I think there were some requests along those lines. I think I cover that in that section.
Actually, since I don't want to interrupt, Your Honor, so let me just go through your topics. And I did have one comment on direct and circumstantial evidence. If you want to hear it now, or I can wait.
Well, right now I'm just going through the general topics.
Yep.
So what you should expect, and if we're missing a topic. So witnesses, expert witnesses. Do you want an instruction about the fact that the defendant is not testifying?
Yes, Your Honor.
Okay. From there, I kind of segue into the defendant's statement, the videotape statement, the instruction that I gave earlier about voluntariness, also concerning the statements by the interrogating officer, or the officer, Lieutenant Whitney, and that those are just for context. Again, the same instruction I gave at the time that the videotape was introduced, along with an instruction about the edits. And then from there, I kind of segue that, or that segues into a more general description of, or instruction on exhibits. Then I will go through as to some of these specific exhibits, subtitles. I will include redactions. Also, the instruction I gave at various points about the graphic nature of some of the photographs. I repeat that in that section. From there, I go into sort of the Bowden, or omissions in police investigation, is sort of the subtitle. That, again, is, at this point, a standard instruction, but I may tinker with that language a bit in the way I've already discussed. And then that segues into evidence introduced for a limited purpose. And so I start with the Bowden information, because I've just talked about Bowden, or Bowden evidence rather, which includes the testimony concerning Mr. Olasak and Ms. Daniele. Also, I repeat the instruction I gave about those. I guess they were surveillance or videos of various parking lots in the interior of the Holyoke Mall. I think they were exhibits 67 through 70. And then from there, I go into sort of the prior bad act instruction, although I don't use that. I don't use bad act, or prior for that matter, but I use that language. I guess I would tack on alibi at the tail end of that. I will also likely repeat, not exactly sure where I'm going to put it, but the instruction on implicit bias that we're encouraged to give, I will give that again. From there, it's the elements, and I will instruct on murder in the first degree, 2 theories, murder in the second degree, and then voluntary manslaughter. And there are two theories that I think are agreed upon. And then that leads to part 3, which is just about deliberations. I guess that's pretty standard. I don't know that I need to even go through that, but that is how it's structured now. So again, if you think I'm missing like a topic, I want to start there.
No, I don't think you're missing any topics, Your Honor.
Okay. So I don't know if you want to be heard beyond what you've submitted in writing. One way we could do this is we could just break for the day. I could do my best to sort of include some of the things that we've talked about, maybe reserve some of the details for tonight as I review more carefully some of the other suggested instructions. And then,
Sorry.
it's okay, and then get you another copy, sort of a more current draft in the morning, and then we can kind of do more of this after closing arguments. So that's
generally fine. That's perfect. We just had one, I guess it's an objection, or not objection, but pet peeve is really, on circumstantial evidence, we know the classic example of the mailman in the mailbox.
I don't use that.
Great. That's what I was going to ask. Thank you.
I don't know why I don't use it, but I don't. It just whatever template I used from the beginning doesn't include that.
Thank you.
So, I mean, I did discuss sort of, and I think this jury, I don't think they need an example of what an inference is. Anything else?
Not from the defense.
No, Your Honor.
I have two questions, sorry, I didn't mean to jump up. So is there a time limit that you want us to consider for closing arguments? I've never tried a case of attorney before, so I don't know how you pick, or whether you pick the 4-person or let the jury pick the 4-person. In my own head, I'm just trying to figure it out.
I typically pick the 4-person.
Okay. I just want to know, do you pick on the jury picks? That's all.
I picked a 4-person. I have someone in my, I kind of been watching the jury, this jury in particular, and I sort of have someone
Sure.
that I think might, I mean, I'm not, it's, I typically pick the 4-person,
Sure.
and then we choose by random lot. Is there anything else? So
then I guess, I didn't know if the jury was going to pick or you were going to pick. That was my big question, Judge. I've had some judges say, you let the jury go in and pick a 4-person. I didn't know if you were one of those. Because I'm not sure that's allowed by the rules, but.
right, no, that scares me, the idea of.
And then my second question is, what do you expect in terms of time limits for closing arguments?
Well,
I know you say you don't give time limits, but.
I don't. I think the rule is that if you're going to go over a half hour, you have to ask for permission. So if you think you're going to go over a half hour and you're asking permission to go beyond that, permission is granted.
Okay, thank you. I think it's close to 40 minutes in my head anyhow. I don't know what
Okay.
it's going to come out with, but.
So, I think that the longer you go on, the more you risk sort of losing the jury's attention. But I'll leave that to you. You're both experienced. I mean, everyone's. Are you going to give the closing argument, Mr. Gagné? I only say that because I think that's what you did last time. But
I'm trying to encourage ADA Sewell to do rock, paper, scissors with me.
Okay.
But I'll most likely be giving it tomorrow.
well,
I am giving it tomorrow.
okay. So everybody here is an experienced trial. I'll leave that to you. I am not going to limit how much time you spend arguing your case to the jury.
And Your Honor, one last thing, since we transitioned from instructions to the jury, to the closing arguments. We would have drafted a motion, but we just didn't have time. I noted in Mr. Gagne's argument last time, 2016, there was an argument which we find objectionable, and I wanted to, I guess, a motion in limine to alert the court that we would object to this. It was the core of it was that Mr. Hoos is a very talented lawyer, and he's attempting to manufacture imaginary doubt and inject it into this case. Don't go for that. And we object strongly to that for at least two reasons. First of all, the idea that counsel is manufacturing anything is placing the integrity and credibility of counsel at issue. The case law is very clear. You can't do that. We think this is a clear example of doing that. And imaginary doubt, frankly, I don't know how to articulate this better, but we just disagree that on the substance that's what he was doing or what we're doing. It's challenging our integrity on the substantive level that we reject, that we're not trying to manufacture imaginary doubt. We actually believe there is real doubt, more than real doubt. So in all seriousness, this is an inappropriate argument from our point of view and highly prejudicial, and it places the credibility of counsel at issue, and that should not be part of the argument. And for that reason, we would object in advance to any sort of argument like that that was made in the third trial.
Okay. I don't know. Mr. Gagne is planning on making a similar argument. I don't know. Do I need to address this?
I don't think it can really be addressed at this point, Your Honor. I plan to go back and obviously read what I said 7 years ago, but I don't. A lot of it may also depend upon what I hear in Attorney Scapiccio's closing. If I hear again about the Commonwealth isn't interested in a search for the truth, again, I think it's premature for us to address this at this point.
Okay. And that's fine. I don't know what I would do, and a lot would have to do with the sort of the context. But if you think you're going to say something that you're pretty sure the defendant's going to object to, obviously we can address that before you begin your argument, because and I'm not going to limit anyone in this way, but I don't know how juries react to interruptions in opening or closing arguments. I would prefer to address objections at the end of the argument, and I understand that sometimes counsel feels compelled to object in that moment, and I'm not going to say that you can. I don't know that I could say that you can't, but to the extent that you foresee something, I'd rather address it sort of either before or after the argument, if possible. So feel free to bring something like that to my attention before you argue, if you anticipate something like that. Zoom tight. Okay. Anything else?
From the defense.
Okay. Again, I'll get you whatever I can get you, but it's not, it's whatever I can do in the next hour. So,
Thank you.
Thank you.
Thank you.
We're all rise.